You. Hear ye. State of Michigan Court of Claims is now in session. Presiding the Honorable Seema. Well, all persons having business herein draw near, give attention, and they shall be heard. God save these United States, state of Michigan.
Morning. Please be seated. Thank you very much. I hope everyone had a good weekend. I will call the case Northland 24-11 Northland Family Planning Center versus AG Dana Nessel et al. We are back here to continue our trial. Before we get started for the day, are there any preliminary matters that we need to discuss?
Just one, Your Honor, an evidentiary issue. We conferred with the intervening defendants, and I believe we have an agreement, but at this time, plaintiffs would move to admit portions of Exhibit 19. Exhibit 19 is the affidavit of Pamela Merritt, who's the executive director of Medical Choice. Specifically, we'd seek to admit paragraphs 1, 2, 7, 8, 9, 10, 11, and 13.
Okay.
And there are about 3 questions from Ms. Merritt's transcript that we would also like to admit. One moment, please.
And this is a resolution because Ms. Merritt is unavailable for trial, correct?
Correct, Your Honor. Ms. Merritt is not able to attend. We plan to have her testify. She's unexpectedly, for personal reasons, not able to be here. So we have discussed, and we would seek to introduce them even if it's objected, but I think we've reached an agreement. And if you need, Kendall, the portions of Ms. Merritt's deposition are page 19, line 23, starting with so through line 24.
I have a redacted copy if I can just present that.
I would just, can we put on the record what the lines are?
Yes.
Yeah, absolutely.
Page 20, lines 1, starting with I'm no to line 6, page 42, lines 16 to 18. And obviously we'll file the exhibits tonight, Your Honor, consistent with the practice.
Perfect.
Your Honor,
And
may I
yes, please.
provide you a copy? So, there you go.
Okay. Then those portions of Ms. Merritt's affidavit as well as the deposition will be admitted into the evidence. Anything else?
Thank you, Your Honor. Not for the plaintiffs.
Okay, great. Then I think we are ready to resume. Plaintiff, please call your next witness.
Your Honor, pardon me, Your Honor. Just for the purposes of the record, any objections, do you mind if we put our appearances on the record?
Oh, yes, please.
Okay.
All right. Good morning, Your Honor. Alexandra Willingham from the Center for Reproductive Rights for the plaintiffs.
I think, yeah, let's have everybody put their appearances on the record again. I should do that at the start of every day.
Sorry, Your Honor. Megan Kelly from Orrick, Carrington, and Sutcliffe on behalf of the plaintiffs.
Molly Blaine from the Center for Reproductive Rights on behalf.
You're going to have to come up to the podium. Thank you.
Hillary Schneller from the Center for Reproductive Rights for the plaintiffs.
Good morning, Your Honor. Allison Epperson from Orrick, Harrington, and Sutcliffe on behalf of the plaintiffs.
Good morning, Your Honor. Rachel Miller from Orrick, Harrington, and Sutcliffe on behalf of the plaintiffs.
Good morning, good morning, Your Honor. Deja Tillman from Goodman, Hurwitz, James on behalf of the plaintiffs.
Defendants?
Morning, Your Honor. Kendall Asbenson on behalf of intervening defendants.
Good morning, Your Honor. John L.A. Tuttle, appearing on behalf of the intervening defendants.
Morning, Your Honor. Assistant Attorney General Daniel Ping, appearing on behalf of Director Hertel, defendant.
Good morning, Assistant Attorney General Christopher Braverman on behalf of Director Marlon Brown.
Good morning, Your Honor. Assistant Attorney General Rebecca Abuna on behalf of the Defendant Attorney General Dana Nessel.
Morning, Neil Chivinetti, also on behalf of Defendant AG Nessel.
Good morning, Your Honor. Brianna Listerman here on behalf of AG Nessel.
Good morning. Thank you very much. With that, plaintiff, please call your next witness.
Thank you, Your Honor. Plaintiffs call Dr. Natasha Bagdasarian to the stand.
I do.
Good morning, Doctor.
Good morning.
It's nice to see you again.
Nice to see you too.
Would you please state your full name for the record?
Natasha Bagdasarian.
Now, you are the Chief Medical Executive for the state of Michigan, aren't you?
I am.
And I know this role keeps you extremely busy, and so I just wanted to say I'm very grateful to you for making time to offer your opinions in this case.
My pleasure.
Now, we met when I took your deposition, right?
Yes,
And outside of this morning, when we introduced ourselves in person, have we spoken any other time?
we have not.
Have you spoken with any other counsel for plaintiffs?
Not counsel for plaintiffs.
You've been Chief Medical Executive of Michigan since 2021, right?
That's correct.
What does your work as the Chief Medical Executive involve?
I am tasked with providing medical and public health guidance to the Michigan Department of Health and Human Services, as well as to the governor.
Is it okay if I call Michigan's Department of Health and Human Services MDHHS?
Yes,
And are you a member of any official advisory bodies?
I am a member of the governor's cabinet.
Are you also chair of Michigan's Public Health Advisory Council?
I am.
Are you a member of any public health task forces?
Several.
What was your employment immediately before you became Chief Medical Executive?
I was the senior public health physician for MDHHS.
And what were your responsibilities as senior public health physician?
I advised MDHHS on clinical and public health issues, including COVID-19.
Could you please describe your education since college?
I went to medical school at Wayne State University. I completed a master's in public health in hospital molecular epidemiology at the University of Michigan School of Public Health. I completed internal medicine residency at the University of Michigan and infectious disease fellowship at the University of Michigan. I also did a brief health policy fellowship.
Thank you. Are you board certified?
I am.
In what?
Internal medicine and infectious diseases.
Are you also an adjunct professor at the University of Michigan School of Public Health?
Yes, and an adjunct professor in the Department of Medicine as well.
Right. What do those roles entail?
I teach medical students, residents. I teach at the School of Public Health, and I round on patients.
Have you held other academic positions prior to the ones you just described?
I have.
Where?
At the National University of Singapore, at Wayne State University, and previously also at the University of Michigan.
Did any of these positions also involve training medical students or residents?
All of them.
Have you served as an advisor to the World Health Organization?
I have.
When was that?
From 2020 through, I think, 2022.
What did that role involve?
I updated guidance on public health issues, including pandemic preparedness, outbreak management, and COVID-19.
So you were busy during that. Yes. How long have you practiced for?
I finished medical school in 2005, so I've been practicing since then.
Are you still a practicing physician?
I am.
Where?
I currently see patients at the Ann Arbor VA hospital.
In what field?
In infectious diseases, which is a subfield of internal medicine.
Approximately how many patients have you worked with over your career?
Thousands.
Have any of these patients been pregnant?
Many.
Did your training to become a practicing physician include training in obtaining patients' informed consent?
It did.
During your 20 years of practice, have you gained experience in obtaining informed consent?
I have.
Can you briefly describe?
Apologies. I
Yeah,
have
there's also water if you would.
Good, thanks.
Okay.
In terms of obtaining informed consent, this is really a process by which you are having a discussion with a patient that meets their needs, that takes into account their medical background, their social circumstances, their wants and desires, to advise them appropriately of risks and benefits, and to obtain their consent for a given procedure or course of medical treatment.
And we will be getting back into those details in a little bit. But just to continue, rounding out your qualifications, have you trained medical students or residents as a practicing physician?
Yes.
Do you have experience conducting medical research?
Yes.
On what topics, broadly speaking?
Public health and internal medicine topics.
And have you published of that research?
Yes.
In peer-reviewed journals?
Yes.
Approximately how many peer-reviewed articles have you published?
I think it's close to about 40 now.
And these articles are in the field of public health?
Most of them, yes.
Are you a peer reviewer for any academic journals?
I am.
Turning back to your role as chief medical executive, you mentioned you provide guidance to MDHHS and to the governor. What does that guidance involve?
Many times it involves a course of how we proceed in terms of managing a threat to public health, but oftentimes it deals with communicating public health and medical information to the general public and making sure that people have the information they need to make the best decisions possible.
In providing guidance that you've just described, does that require maintaining expertise on the state of public health in Michigan?
It does.
How do you maintain expertise in the public health of Michiganders?
Number one, I think by teaching medical students and residents, I'm constantly reading, and in teaching, I'm able to keep up to date on a lot of topics. I also read numerous medical journals. And in terms of Michigan specific public health, I look at our data almost daily.
You mentioned reading medical journals. How do you determine what is reliable medical literature?
Because of my background in epidemiology, I have training to determine whether a study is well written. I also look at the journal itself, and there are certain journals that have a very high reliability factor. So for example, if I'm reading something in the New England Journal, I tend to know that it has been well vetted, but I, of course, will vet that article myself as well.
As part of maintaining your expertise, do you consult with other physicians in Michigan?
I do.
In which fields?
I talk to the medical directors of all the local health departments. I speak to internal medicine physicians on a, I think, almost monthly basis, big society groups. I give grand rounds presentations to internists, pediatricians, OBGYNs constantly. So I'm talking to physicians all across the state on a very regular basis.
And do any of the physicians you speak with provide abortion care?
Yes,
Does the state of public health in Michigan include the current state of reproductive health in Michigan?
yes, reproductive health is healthcare.
Can you tell us a little bit more about why that's the case?
If you are making, sorry,
Oh, no worries.
if you're making a decision about when or if to have a child, those decisions not only impact your current state of health, but also your future health risks. They impact your educational decisions, your career decisions, and impact other members of your family. There are many impacts on how much you will earn, how you will be able to attend future medical appointments. So all of these have a lot of interplay, and reproductive health as such is one of the biggest, most critical decisions that we make about our bodies.
What do you consider to be reproductive health? What does it encompass?
It encompasses not just decisions on when or if you decide to become a parent, but also the how. It encompasses treatment of sexually transmitted infections. It encompasses general preventative care. So it's a wide range of things.
Does monitoring the state of public health in Michigan include the state of healthcare access throughout Michigan?
Yes.
And from a public health perspective, why do you care about healthcare access?
My role as a public health physician is really to make sure that everyone in our state has access to the healthcare that they need. And oftentimes it is those who are in vulnerable communities that have limited access to healthcare that I have to be most aware of and cognizant about. That includes people who are uninsured, underinsured, people in minority communities, people with difficulty accessing transportation, young adults. So making sure that those particular vulnerable groups have access to the healthcare they need is really a critical part of my job.
Are there areas, regions of Michigan where vulnerable communities are particularly concentrated?
Yes.
Could you describe a little bit, please?
So when I think about vulnerable communities, one of the I'm so sorry.
Take as many breaks as you need.
This is like a chronic thing. So vulnerable communities, a few different specific communities come to mind. So number one, I think about folks living in rural communities where they may be faced with physician shortages, with transportation barriers. I think about folks in some urban parts of our state where in particular, maternal mortality tends to be higher, especially among Black and Brown communities. I think about folks who are migrant workers, folks who may be undocumented, who may have difficulty accessing healthcare. So these are all groups who really can be most vulnerable when it comes to healthcare access across the board, but specifically reproductive healthcare access.
Just to underscore the point that you've made, why does these communities struggling with healthcare access matter to public health?
We can't have a robust health system if we are leaving big swaths of our population behind. We can't move forward as a society, as a state. We can't be a healthy, vibrant community if we are leaving big chunks of our people behind. Making sure that we are addressing sexually transmitted infections, making sure that we are addressing maternal mortality, that we're really serving those who need it the most. That's the only way to really lift up our community across the board.
Now, you mentioned reproductive health care. Is access to abortion care an issue that you pay attention to?
It is.
And do the communities that you have described struggle in particular to access abortion care?
Yes.
Is, can you describe why that's the case?
So as I talk to both community members and healthcare providers across the state, there are a few themes that I hear consistently. That for reproductive healthcare in particular, folks are dealing with some of the same barriers that they deal with across the board. So transportation issues, difficulty taking time off work, difficulty obtaining childcare. Now, when you think about young women in particular, we know that many of the individuals who are obtaining abortion care in our state are already mothers, young mothers. And for them, some of these challenges are compounded. Again, when we're adding the barriers of transportation and childcare and taking time off work, but also if we think about some of the barriers that have legislatively been put into place, including the 24-hour waiting period, that further compounds all of those issues that I just described.
Well, that's an excellent segue to getting into the details of this case. So just to level set, another physician who testified referred to the standard of care. Is that a term that you're familiar with?
It is.
How do you define the standard of care, medically speaking?
The standard of care is the best practice that we could offer an individual that would be consistent with medical guidelines, consistent with what other healthcare providers would provide, and that takes into account the individual needs of that patient.
Are there any authoritative sources a physician looks to in determining the standard of care?
You would look at published medical guidelines. You'd look at peer-reviewed studies. You would attend conferences and talk to your peers about similar types of care that they provide.
And how do you know what guidelines that you mentioned are credible sources?
Part of it is looking at a guideline yourself and making sure that it is well sourced and well written. But part of it is also looking at who is publishing that guideline and whether they are a biased or unbiased source.
You previously testified that you have training and professional practice in providing informed consent.
Yes.
Does the standard of care require a healthcare provider to obtain informed consent to perform a medical procedure?
Yes.
Does the standard of care impose any requirements for informed consent?
Sorry.
Oh, no. I'll do the same.
The standard of care would mean that you are obtaining informed consent in a way in which your patient understands, in a way that describes risks and benefits of a certain procedure, and in a way that is nuanced and appropriate for that patient.
So for informed consent to be comprehensible to the patient and to be nuanced to the patient, does that require the informed consent process to be individualized to that patient?
It does.
Why?
Every patient has a different set of needs and requirements. Some of this is based on that patient's medical history. So if you have a patient with diabetes or a history of a bleeding disorder, the informed consent for that patient is going to differ. Every patient also has a set of social circumstances. And again, you have to make sure that your informed consent addresses all of those things and is tailored to your patient. We also know that some patients struggle with medical literacy, and so making sure that the informed consent you're providing is appropriate for their level is also one of the things that you should do.
Does the standard of care say anything about autonomous decision-making?
It does.
You just briefly described.
Patients should be able to make decisions about their body and have bodily autonomy. And so your informed consent should respect that bodily autonomy and do everything you can to give them the best information so that they can make the choices that are best suited for them using their autonomy.
So building off of that, does a patient's goals for treatment affect how the provider goes about the informed consent process?
It should.
How so?
If a patient has told you that their goal is X, your informed consent should really take that goal into account and should be based around that goal. So if, for example, we are talking about abortion, if a woman comes into your office and tells you that they want to terminate that pregnancy, then your informed consent process should keep in mind that their end goal is to terminate that pregnancy.
So do I understand you to be saying that if a patient comes in and says, I want to terminate my pregnancy, it would not be appropriate for the provider to then say, well, here's some information about parenting?
Correct.
And more generally, should a medical provider give a patient information that is irrelevant to their goals for treatment?
No.
Is it important that the information given to the patient is accurate?
Yes.
Why?
Number one, we're attempting to give a patient the best possible data and tools for them to make decisions that are appropriate for themselves. And if you are giving them information that is either irrelevant or inaccurate, you are not giving them the data that allows them to make the best decisions for themselves. You don't want to provide information that either distracts them or information that is untrue, because they cannot make the best decisions for themselves given inaccurate or irrelevant information.
You said that there's information could distract a patient.
Yes.
Does that mean that accurate information could be presented in a misleading way?
Yes.
Could you describe how that might occur?
If we are talking specifically about the materials that MDHHS provides, one of the ways that accurate information is provided in a way that is potentially irrelevant and biased is by providing someone who seeks to terminate their pregnancy with information on infant safe sleeping practices and infant feeding practices. Those pieces of information are technically accurate, but they are so irrelevant as to be biased and potentially even coercive.
Well, let's talk about the document that you mentioned. May I approach? All right, if you could please open your binder and turn to Plaintiff's Exhibit 4 when you're ready.
Yes.
And then you'll notice on the bottom right-hand corner, there's a page number out of, I think, 45. Could you please turn to page 27? Is this the beginning of the parenting information that you were talking about?
It is.
And then just for the record, are these materials prepared by MDHHS?
They are.
Are they required to provide these materials?
They are.
And the patient must review these materials before obtaining abortion care?
That's correct.
Great. On this parenting information, does it benefit the health of patients seeking abortion to require them to view parenting information?
It does not.
Why not?
For someone who is seeking to terminate a pregnancy, in my opinion, there is no reasonable reason to require that they review information about breastfeeding, about sleep practices, about car seats, etc.
Why not?
For someone who is seeking a termination, this material is so irrelevant that it seems coercive and potentially even designed to cause feelings of guilt.
And why, in your opinion, is it designed to cause feelings of guilt? Or might it be designed to cause feelings of guilt?
I can't speculate as to why these laws were enacted, but I can tell you that in terms of the standard of care, it makes no sense to provide materials about infant care when there is no infant.
Do you have an opinion on whether these materials send a message to a pregnant patient reviewing them?
In my opinion, it does.
And what is that message?
That message is that you should rethink your choices, and it emphasizes parenthood over termination of a pregnancy.
Let's look at another part of this document. I'm going to make you go back to page 6, please. Are pages 6 through 14 information about the risks of medication and procedural abortion?
They are.
Say, for example, a patient is going to receive a medication abortion. Does it benefit that patient's health to review information about a dilation and evacuation procedure?
No.
Why not?
They're two very different procedures. If you're having a medication abortion, there is no reason for you to review materials about another procedure that you have already decided against in consultation with your physician.
And here, the patient is being required to review this information before they've even had that consultation with a physician.
That's correct.
So does that mean that they necessarily know what procedure they're even eligible for?
No. And just to say, in some cases, they're reviewing this material after consultation with a physician, depending on what has happened until that point. So this may be someone who is not necessarily seeking a termination of an unwanted pregnancy. This could be someone who is having termination of a wanted pregnancy with a congenital malformation, for example. So you have already potentially in those situations had multiple conversations with your healthcare provider, and then you are asked to look at material that is completely irrelevant to you.
Generally, does it ever benefit patient health to review risk information for medical care they will not receive?
In some cases, yes. But again, all of this is very nuanced and should be made by a healthcare provider who is taking care of that individual patient.
And why is that the case?
So if, for example, you are terminating a pregnancy before 12 weeks of gestation and you are deciding between a manual vacuum aspiration and a medication abortion, if you're deciding between those two things, yes, providing information on those two procedures makes sense. But that's something that the healthcare provider in consultation with the patient should decide. What are those decisions that the patient is making and what information should be provided at that time?
Do you have an opinion on whether reading information about risks of a procedure that you will not have has an effect on a patient?
I think that if you are being asked, the way that the law had described this, or the way that the law had been designed, if you are reviewing information without a clear understanding of which risks applied to you, it could be very confusing. It could be confusing as to whether the lower risks of a medication abortion apply to you or the somewhat higher risks of a D&E apply to you because you're just seeing this information on a website. It could be confusing as to why your healthcare provider is asking you to review this information when potentially you've already had a conversation about what your particular circumstances allow for. It could be confusing to read about a procedure that you are not eligible for. It just doesn't make a lot of sense for legislators with no medical background to insert themselves in this conversation between a healthcare provider and a patient.
If a patient, so you talked about a patient being confused about what risks apply to them. Do you have an opinion on whether that could affect a patient's risk benefit assessment?
I think so. I think if you are reading about the risks of a D&E, which is very different than the risks of a medication abortion, you could say, well, gosh, I thought we were just talking about medications. All of a sudden they're talking about a procedure. I'm not interested anymore. I think it could shake your confidence in your healthcare provider as to why they're providing you with material that is so irrelevant. I think that there are some real consequences of receiving material in a way that is not nuanced and tailored for you by your healthcare provider.
And the effects that you've just described, could that affect a patient's autonomous decision-making?
Absolutely.
I'd like you to take a look at page 6. See the heading that starts risks and complications?
Yes.
And so the paragraph above that, what is the first sentence of that paragraph?
It's rare, but some individuals may have feelings of sadness, guilt, anger, trouble sleeping, or doing daily activities after an abortion.
Does this warning benefit patient health?
I don't think that reading it in this way benefits anyone.
Why not?
I think that, again, every individual is different, and those types of conversations are best had in a nuanced way with your healthcare provider. Number one, we know that the same types of emotional feelings can happen not only after an abortion, but after pregnancy and delivery. These feelings can happen after other types of medical procedures, a hysterectomy, for example, a mastectomy for breast cancer. We don't mandate someone read this statement for those other types of procedures. And it's unclear to me why we would mandate it only in this one particular instance.
So the next sentence does say that these feelings can happen after childbirth, right? Does that change the opinion you just gave?
It doesn't. I think you could very easily say these symptoms can occur after the birth of a baby or after a miscarriage or after any number of medical procedures. Again, this sentence is not mandated in any of those other procedures.
But it is mandated here.
But it is mandated here.
Could you please turn to page 16?
Sorry, Your Honor, I didn't catch that. Did you say
1-6.
1-6? Okay, thank you.
Are these the beginning of the images and descriptions of fetal development that MDHHS is required to include in this packet?
Yes.
Is there a medical reason to show a patient seeking abortion an image of a fetus?
Not unless they are requesting to see an image.
Why not?
Again, it can feel coercive when provided in a way like this. It can also be misleading. I don't know if am I allowed to just bring up an example from my deposition?
You're certainly allowed to bring up an example. You don't have to root it in your deposition, but
Okay.
please give us an example.
Well, this is an example from my deposition, and no offense at all to Mr. Tuttle. But I will say one of the questions I got in my deposition is, isn't this so needed and relevant? Because when you are at home having a medication abortion or a miscarriage, shouldn't you be able to pick out the fetal parts? Shouldn't you be able to actually see this material that's being passed out? And this was a question asked of me by the intervening attorney. And even the intervening attorney missed the fact that at week 4, we're talking about something the size of a poppy seed. And at week 6, we're talking about something the size of a mustard seed. And so no one is actually seeing these fetal parts. I think these are designed to make women think that they are going to be passing something that visibly appears to be a fetus, when in reality, you would need medical training, a dissecting microscope, and an intrinsic knowledge of fetal anatomy to be able to find those elements of anatomy. So no disrespect to Mr. Tuttle. I just wanted to provide an example of how even the attorneys involved in this case, who are much more well-informed than the general public, can be led astray by pictures like these.
And then even for fetuses in a later stage of gestational development, is there a medical reason to compare fetal size to a piece of fruit?
There's no medical reason for that.
Why?
There is just no reason for it. When you are dealing with a woman who is pregnant, if that individual has had an ultrasound, you might talk to them about what was seen on the ultrasound. I have never used pictures like this in my clinical practice, nor have I heard of other people using pictures like this routinely. Although again, if someone asks for these types of images, it's your duty as a medical provider to find them.
You just compared and contrasted these images to an ultrasound. Do the images and descriptions on these pages always accurately reflect the state of the patient's pregnancy?
Absolutely not. We talk a lot about abortion, thinking about this as being something that an individual is choosing, and that this is an unwanted pregnancy that they are choosing. We have to recognize that many, many terminations occur because of congenital issues and congenital deformities that are incompatible with life. And in those situations, when you're talking about formation of limbs or formation of heart chambers, what is shown in these pictures may not be the reality for that individual person.
Is there a risk of misleading the patient about her own pregnancy?
Absolutely.
You briefly hinted at this, but I want to ask you directly. Do you have an opinion about what the purpose is of these images?
I can't speculate as to why these laws were passed. But to me, it all seems very coercive and manipulative.
And why do you see it as coercive and manipulative?
I can't think of a reason to talk to someone who is terminating their pregnancy about infant safe sleep, nutrition, the size of a fetus, compared to a piece of fruit, unless your goal was to make them question their decision-making.
You have identified a variety of pieces of this information that is inaccurate or possibly slanted. If a provider then tries to correct what you've identified through a conversation or their own informed consent process, does that fix the problems you've identified?
I don't think it does. I think you could actually end up in a situation where that patient feels even more confused. Why are you asking me to look at these images? Why are you telling me things that are incorrect and then telling me that I should disregard this information? Which one of these sources should I trust? I think it not only makes your relationship with your healthcare provider potentially more fraught, but as a public health agency, I also want the Michigan Department of Health and Human Services to maintain credibility in providing factual, correct information. And I don't think this helps us maintain our credibility either.
When you say it doesn't help MDHHS maintain its credibility, is that limited to abortion information?
No, most of the information we put out has nothing to do with abortion. Most of what we put out has to do with things like vaping in young adults and vaccines and the hazards of smoking and substance use disorder. And so if we are making our materials seem questionable. If healthcare providers out there are having to show our materials and then say, this actually doesn't apply to you, the government is forcing you to look at this, I think it undermines our credibility in all of those really vital components of public health in a time where mistrust and disinformation is on the rise.
Could you please turn to page 24 of this packet? Is this the beginning of the list of entities that provide free ultrasounds in Michigan?
Yes,
Is this a list put together by MDHHS?
it's a list compiled by MDHHS from entities that have requested to be on this list.
Is MDHHS obligated to compile this list?
We are.
So to your understanding, if an entity requests to be on this list, is MDHHS obligated to include them on the list, even if they provide free ultrasounds, even if that entity does not employ trained medical providers like physicians or APCs?
Yes.
What if it does not employ trained ultrasound technicians?
We are still obligated to put them on the list.
Is MDHHS also obligated if the entity does not have staff that can read ultrasounds for gestational dating or diagnostic purposes?
Correct.
Looking at this list, it contains many entities with names such as CareNet, Life Clinic, Life Plan, Life Choices, Life Resources, and Heartbeat, right? Are you familiar with any of these entities?
Not personally, no.
Are you familiar with enough to, would you characterize these entities in any specific way?
Yes.
Objection, foundation.
Okay, let me try again. In your expertise, do the entities I have just mentioned have a certain reputation?
They do.
Could you please describe that reputation?
Yeah. So many of the entities on this list are referred to as crisis pregnancy centers and are entities designed to push women away from abortion. So many of these organizations don't have trained medical staff, are not in fact licensed medical facilities, and are offering ultrasounds solely for the purpose to discourage women from getting abortions. Now, the difficulty is there's no good way to tell which ones are coercive. Many of them have websites.
Objection, foundation.
Your Honor, she's the chief medical executive for the state of Michigan. She is the public health expert for the state, and she has testified that reproductive health is well within her purview as the public health expert. I think we've laid sufficient foundation.
Your Honor, she's testifying that there's no good way to tell if they're coercive or not, but she is able to tell that the material's coercive. There's means of testing if something's coercive. She has no personal knowledge, and she's testing, and she testifies that she knows their reputation. So she hasn't testified that she knows enough about them to determine whether or not it's impossible to tell if they're coercive or not.
I think Mr. Tuttle is missing the nuance of what I am understanding from Dr. Bagdasarian's testimony, that she is saying that she knows the reputation of these crisis pregnancy centers as being anti-abortion, but then is making the more nuanced point that she cannot, that she does not have the foundation to specifically say whether those anti-abortion centers are actually coercing their patients to not have to not have abortions. And I will contrast that to the MDHHS materials. Dr. Bagdasarian provides guidance to MDHHS. She is ultimately responsible for MDHHS's content and policies. And so it's a very different situation.
Your Honor, considering that learned counsel here is admitting that there's no way to determine if any of them are in fact coercive, I withdraw my objection.
Okay, thank you.
May I continue?
Yes, please.
Oh, okay. So, I think this is very relevant to me because we at MDHHS oversee this list. And what we have found is when we look at these specific entities, it's very hard to tell whether they have medical staff employed, whether they are able to interpret ultrasounds appropriately. And this is a well-known issue with providing a list of free ultrasound providers, is that many of them are not appropriately qualified to interpret the images that they are providing.
What is the risk to patients of someone reading the ultrasound who lacks the necessary qualifications?
If you are going into a center and having an ultrasound with someone who does not know how to properly interpret that ultrasound, they could miss an ectopic pregnancy. They could miss a pregnancy with major congenital malformations. They could miss a pregnancy that is no longer viable. And so it is, in fact, dangerous to provide ultrasounds to individuals who are pregnant without being able to interpret them.
And for those of us who don't have medical training in the room, could you please explain why the misdiagnoses you just mentioned are a problem?
So an ectopic pregnancy is a potentially life-threatening complication. It's a pregnancy that's outside of the uterine cavity, and you could end up with for example, one of the areas where these ectopic pregnancies like to arise is in the fallopian tubes. And if that fallopian tube perforates, a woman can become septic, can hemorrhage, and can exsanguinate and die. So it's a potentially life-threatening thing to miss.
Just a follow-up question about something you said a couple of minutes ago. You said it's hard to determine what medical staff they may or may not have. Even if you could determine what medical staff they have or don't have, are you still required to include this facility on the list if they provide free ultrasounds and they request to be included?
Yes.
One last piece of the mandatory counseling that we have been discussing to talk about. We've heard in this trial how Michigan requires patients to review information about coercion to have an abortion and requires providers to screen for coercion to have an abortion. Are you familiar with these requirements?
I am.
Is the state mandated coercion screening individualized or standardized?
It is standardized.
Should coercion screening be individualized or standardized?
It should be individualized.
Why is that?
Because so much of this depends on, let me rephrase that. Eliciting the best response really depends on establishing rapport with your patient and understanding their particular scenario. I think that coercion screening can be done in a variety of different ways. It would be done differently, for example, with someone who is showing up to your appointment with a black eye or bruises, where you could be asking where those are coming from. It could be very different when someone is opening up and telling you how supportive and wonderful their partner is. So if you're not doing a nuanced and individualized coercion screen, it's less likely to yield good results.
Absent these challenge requirements, do abortion providers typically screen for coercion as part of the informed consent process?
Yes.
Is it standard of care to do so?
Yes.
For that screening, do providers just screen for coercion to have an abortion, or also for coercion to remain pregnant?
I think that coercion screening is really a standard part of both of those things, but also it should really be a standard part of medical care in general. So if you are, for example, a plastic surgeon who is giving someone a breast augmentation, there should be coercion screening there. If you are a plastic surgeon giving someone a rhinoplasty, there should be coercion screening there. So this is not just something that applies to abortion and pregnancy. This applies to a whole variety of medical procedures.
In your understanding, is the coercion screening outside of abortion care that you've just described required in Michigan?
Do you mean required by law?
Yes.
Abortion screening is required by law. Or sorry, coercion screening is required by law in Michigan only for abortion.
If one of the intervening defendant's witnesses were to testify that in the absence of the abortion-specific coercion screening requirement, abortion providers in Michigan would cease screening for coercion, would you agree with that testimony?
I would not,
Why not?
because it's part of the standard of care.
Is Michigan's abortion-specific coercion screening requirement consistent with the standard of care?
I would say that it is less optimal because it is so standard and lacks any nuance.
So before we leave the state mandated counseling, does this state mandated counseling further informed consent?
It does not further informed consent that is already done within the standard of care.
Just for the record, why does MDHHS include the inaccurate information that you have described?
Just to be, I won't address the witness, but I am not sending any signals that she needs to stop speaking.
Okay, you're just doing what you're doing.
Making
Okay.
noise.
Let's continue.
I'm sorry, which information? Could you say that again?
Yes. You have listed several criticisms of the MDHHS material. You have a professional relationship with MDHHS.
I do.
How does it come about that material that you were ultimately responsible for has inaccurate and biased information, as you've described?
I would say that this is the best we can do under the existing law.
Does the state mandated counseling benefit patient health?
No,
Can it harm patient health?
it could.
Do you have any other testimony about the state mandated counseling that you would like? Is there anything we have not discussed that you would like to mention?
I don't think so.
Okay, great. You mentioned,
I have a
oh,
quick,
yes, please.
clarification. When you're talking about the state mandated counseling, are you talking about all of it or just the coercion counseling at this point?
I was referring to all of it.
Okay,
That was, yeah.
thank you.
Okay. You mentioned earlier that Michigan requires a 24-hour waiting period between the patient receiving the state mandated information we just discussed and obtaining abortion care, right?
Yes,
Is the mandatory 24-hour delay consistent with informed consent?
it's consistent with the law. It is not consistent with standard of care.
Why is it not consistent with the standard of care?
There is no reason for a 24-hour waiting period for everyone. And I'll explain what I mean by that. For many women, asking them to wait for 24 hours and come back for care is additional burden when it comes to childcare, transportation, taking time off work. And we all know that in some cases, for medical reasons, a waiting period is necessary. This 24-hour waiting period does not address those. issues and is completely arbitrary. So if, for example, someone had a bleeding disorder and they needed to hold their blood thinners, this 24-hour waiting period would not address that. If someone had, untreated hypertension and we needed to stabilize their blood pressure before they underwent a procedure, this 24-hour period would not assist with that. It is an arbitrary period of time that, again, doesn't serve a medical purpose.
So if one of intervening defendant's witnesses were to testify that this 24-hour delay improves patient decision-making, would you agree?
I would not.
In your opinion, does the mandatory 24-hour delay benefit patient health?
It does not.
Why not?
I talked about some of the barriers to access. So actually, let me answer this two ways. Number one, there are some cases in which this 24-hour arbitrary waiting period is actually occurring, in the case of a non-viable pregnancy. It could actually be occurring after several conversations with a healthcare provider already, several gut-wrenching, really difficult conversations and visits. And then there's just this arbitrary 24-hour waiting period at the end of that. And then on the other hand, for an uncomplicated pregnancy termination, we've talked about vulnerable women. Those tend to be women who are low income, who are working minimum wage jobs, who may be young mothers, who are arranging for childcare, who don't have reliable transportation. And for them, having two visits and having this 24-hour waiting period can be additionally detrimental. And that 24-hour waiting period could actually turn into a 1 week or 2 week waiting period, meaning that it could actually push them into a more invasive procedure.
Does what you just described also apply if a patient cannot get the care they need at the first appointment for any reason? Like, do the barriers you've just described apply if the patient has to reschedule as well?
Yes.
If a witness for the intervening defendant were to testify that a 24-hour waiting period helps ensure a patient has no medical contraindications, would you agree?
I wouldn't even understand why that statement makes sense.
Let's analogize this to some other reproductive health care. Does Michigan law require a 24-hour mandated delay before a patient can access miscarriage care?
No.
In your understanding, does Michigan law require a 24-hour mandated delay before a patient can get an IUD or other contraception?
No.
What about a vasectomy?
There is no state mandate for a 24-hour waiting period there.
Does the 24-hour mandatory delay affect access to abortion care?
It does.
How so?
For the same reasons that I mentioned before. So if we're talking about vulnerable women, women who are working minimum wage jobs with issues with childcare, with transportation, rural residents of Michigan, not only could this 24-hour waiting period and coming back to a clinic be an obstacle, it may actually preclude them from getting a desired pregnancy termination. If someone is traveling from the UP into the lower part of the state, they may not be able to make that trip twice.
Now, I'm not from Michigan, so I assume UP means Upper Peninsula.
Yep.
Okay, thank you. In your opinion, does the 24-hour mandatory delay harm patient health?
Yes.
How so?
Because again, it introduces barriers to a form of healthcare where there should not be a barrier. There are many barriers that we can't address because of infrastructure. And this is a barrier that is simply put there to make this care more difficult for women to access.
Objection foundation. I'll explain more. She's already testified. She cannot speculate as to why the law was passed.
Your Honor, the question was about whether the delay harms patient health. I did not ask about the intent of the law and understood Dr. Bagdasarian's response to be about the effect of the law.
I'm going to overrule the objection. I think she's testifying about the impact of the law on the patient population.
Thank you, Your Honor.
Let's talk about the last requirement that we're challenging in this case. We've heard at this trial about how Michigan requires abortions be provided by physicians. Are you familiar with this rule?
I am.
Is it okay if I refer to it as the physician-only rule?
Mhm.
Are you familiar with the term advanced practice clinician or APC?
I am.
What is an APC?
An APC is a nurse midwife, a physician associate, someone who is able to provide someone who's received training that allows them to provide healthcare.
Now, I'm sorry, I'm going to take you back just very quickly. There was a question I forgot to ask about the 24-hour delay. We talked about how it impedes access to abortion if a patient has to make multiple trips to a clinic. But does what you described also impede access to abortion even if the patient only has to make one trip?
It is very rare that a patient only has to make one trip. Most women don't know about the materials online. They don't know that those materials can be reviewed online. They don't know how to.
Objection, Foundation.
Doctor, you testified earlier that you have spoken with physicians who provide abortion care in the state.
Yes, many.
Did those conversations include their patients' experiences navigating Michigan's abortion laws?
Yes, I've also moderated many, many town halls talking to women who have terminated pregnancies.
And so from these conversations, without relaying the specifics of what was said to you, what is your understanding? Do you have an understanding about how well abortion patients in Michigan tend to understand what is required to access abortion before they try to access the care?
I do.
And what is your understanding?
My understanding is that many of them don't know they can access these materials online. They don't know that there's a state law that mandates they require certain, that they read certain types of information. And many of them show up to a clinic expecting to receive an abortion that same day and are surprised when they cannot.
Even if a patient did know about the requirements and was able to complete the online process, does your testimony about the barriers that they face to get care still apply?
Yes.
Let's go back to APCs. You've told the court what an APC is. Are you familiar generally with the type of care APCs provide in Michigan?
I am.
What kinds of healthcare do they provide?
I have worked with PAs and NPs who are part of the clinical care team, who obtain medical histories, who are a part of rounding, post-operative care. And I've also interacted with many nurse midwives who are able to deliver babies, who are able to place IUDs, perform pelvic exams, etc.
Does the care Michigan APCs already provide include miscarriage care?
It does.
How do the medications or procedures used in miscarriage care compare to those used in abortion care?
They are the same.
How does abortion care compare in terms of risk to care that APCs in Michigan already provide?
Given that the risk of complication or death from an abortion is much lower than the risk of complication or death from childbirth, I would say that they already perform procedures, including delivery, that are much riskier than abortion care.
So in your opinion, are APCs capable of safely providing abortion if it is within their scope of practice?
Yes, if it is within their scope of practice and training.
If a witness for the intervening defendant were to testify that physicians are always more qualified to handle complications than an APC is, would you agree?
I would not.
Why not?
It really depends on the type of training that individual has received. So for example, a nurse midwife who has, already delivered 1,000 babies is much more qualified to handle the complications of an abortion than, for example, a pathologist who has never delivered a baby, but who is a physician.
And what if a witness for the intervening defendant were to testify that APCs are always less able to recognize complications from abortion than a physician?
Again, it really has to do with the training of that individual. And if it's someone who is assisted or if it's someone who has managed pregnancy and childbirth and has the appropriate training, there is no reason why they could not recognize the complications following abortion.
In your public health expertise, does the physician-only rule affect the availability of abortion care in Michigan?
It does. We have a physician shortage. We have an OBGYN shortage, and we see this predominantly in rural parts of the state, including the Upper Peninsula.
How does this affect the supply of eligible abortion care providers?
It means that there are fewer of them.
Does this make it harder to access abortion in Michigan?
It does, especially if we're talking about a procedure. There are very few abortion clinics the further north we go in the state. And again, particularly for women in rural parts of the state, it can be difficult for them to access an abortion in a timely fashion.
You've mentioned rural communities have particular difficulty accessing abortion care. Are there other communities that have particular difficulty accessing abortion care due to the physician-only rule?
I think that in general, the fewer providers we have, the more this is going to impact vulnerable communities. And by that, again, I'm talking about women who are uninsured, underinsured, living below the poverty line. They tend to be impacted the most by these types of shortages.
In your opinion, how would removing the physician-only rule affect the supply of providers qualified to provide abortion in Michigan?
It would improve access.
Why?
It would allow for PAs, NPs, midwives to perform abortions in parts of the state where there's currently a lack of access.
Considering everything we've just talked about, the physician-only rule, does this rule benefit patient health?
It doesn't.
Does it harm patient health?
It could.
Why?
Again, it's just another barrier to access. Many of these obstacles seem designed to limit access to abortion care.
In your opinion, would removing the physician-only rule harm public health in Michigan?
In my opinion, it would not.
Why not?
We have data to show that abortions can be safely performed by APCs.
Would removing the physician-only rule benefit public health?
It could, yes.
What effect would removing the rule have on health outcomes in Michigan?
Improving access could lead to it could lead to people being able to access abortion care earlier, which is less risky for that individual. It could lead to women not having to travel far from home, having to, again, look for childcare, transportation, all of those other barriers.
We've talked a lot about harms to patients, and you also mentioned harms to MDHHS.
Mm-hmm.
Do the restrictions challenged here also impact providers?
They do.
How so?
Are we talking about just the physician-only rule, or are we talking about all of
No,
this?
sorry, yes. Let's
of
talk
this.
about all the rules together now.
You know, if we talk about what has happened over the last few years with misinformation and distrust of people in any sort of official capacity, that has impacted physicians as well. I've spoken to many physicians around the state who feel that their patients just don't trust anything anymore. They don't trust science. They don't trust data. They don't trust what is being told to them. And I think putting barriers in place that are unnecessary, having to explain, here's some information, but you don't really have to believe it because I'm forced by law to give this to you, but here's the actual information. It again erodes some of that patient-physician trust and rapport that is one of the last remaining sources of good healthcare information that we have out there.
How does the erosion of trust and rapport affect the physician's ability to do their job?
I have heard from physicians in many different fields that patients are just more skeptical about getting tests and getting very routine things done. I think as we see, and we want patients to be advocates for their own health. We want them to ask questions, but we are just seeing such an erosion of trust that I think having this added burden to provide irrelevant, potentially biased, potentially coercive information, it's just one more chip at that already fraught environment that we're working in.
Do any of the requirements affect the treating provider's ability to exercise their clinical judgment?
Yes.
How so?
There is this extra. I think that having a physician-patient interaction under this cloud of doubt and mistrust, it can just sort of stifle conversation and lead to people perceiving information in ways that aren't necessarily beneficial to them. I can give examples. I don't know that they would be helpful here. Let me know if.
You've testified that you have experience training medical students and residents.
Yes.
Do the problems we've discussed affect the training of future abortion providers and how to obtain informed consent?
Yes.
How so?
I think that some of the ways that this conversation has been steered by legislation, as our medical students and residents and even fellows are learning this sort of way of practicing, they may assume that this is the way things have to be done as they go out into other states where this is not the requirement. It's again confusing to add in this whole layer of unnecessary documentation, of unnecessary and potentially biased information. Confusing for the patient, confusing for trainees, confusing for everyone who's a part of this.
We're almost done. I'd just like to talk briefly about how the laws we've challenged here fit within Michigan's public health landscape more broadly. Independent of this case, when the state of Michigan wants to distribute public health information, as you've mentioned, MDHHS does frequently, what strategies or tools might it use?
We we have websites that we manage. We will conduct public health media campaigns. We'll put billboards up. We'll have radio ads, TV ads, social media. We get information across to people in a number of different ways.
And do the tactics that you've just mentioned make information available to Michiganders without requiring them to view it?
Yes.
Could you give an example of a time the state has done this?
We're doing a huge campaign right now. You may have seen some of our materials on substance use disorder. And we have information available on where you can access naloxone and how you can access treatment. And we've got prevention messages for parents to talk to their teens.
In your public health expertise, does Michigan treat abortion the same as it treats other healthcare?
No, it does not.
How so?
There is nothing else in my knowledge and understanding of the Michigan Department of Health and Human Services, the way that we operate as a state health agency. There is nothing else where we are mandated to provide specific information, especially to that providers have to then verify that their patient has seen and digested. We typically are conducting public health campaigns where we are trying to make information freely available. Again, give people the best information that we think could be helpful to them. But usually we follow up with, if you need specifics, talk to your healthcare provider. So usually we're providing very broad information. And then we're saying, if you need any details that's tailored to you, talk to your healthcare provider. This just seems like a very backwards way to do this, where someone already has a healthcare provider and their healthcare provider is making sure that they have come to us for material that we are mandated by the legislature to provide. It is very different from how we operate in any other public health sphere. And frankly, it makes no sense to me.
And is there a medical reason for this differential treatment?
No.
So to sum up, in your expert opinion, do any of the laws challenged here benefit the health of Michiganders?
No.
Do each of the laws challenged here harm the health of patients in Michigan?
Yes.
Nothing further on direct.
Okay, thank you very much. Let's take a 15-minute recess before we start with the cross-examination. Right?
Or the other stuff.
Thank you. May be seated. Welcome back. Thank you, Dr. Bagdasarian. You are still under oath. Counsel, you want to begin your cross-examination?
Thank you, Your Honor. Dr. Bagdasarian, it is a pleasure to meet you in person, finally.
It's a pleasure to meet you too.
So I have a number of questions, I'll be honest. There are plenty, but I will do my best to move it along. And simple, direct answers would go a long way towards that goal. Right. So the standard of care means the level of care, skill, and treatment that a reasonably competent healthcare professional with similar training and experience would provide under similar circumstances, correct?
Correct.
And that standard applies to all clinical practice, right?
Correct.
And it applies to abortion because abortion is a medical procedure, right?
Correct.
Right. And the standard of care for informed consent means a patient will not undergo a procedure without being duly informed and without voluntarily granting consent, correct?
Correct.
The same standard applies for abortion informed consent.
Correct.
Okay. And isn't it true that an informed consent procedure that does not meet the standard of care is invalid, and therefore the proposed treatment cannot be performed?
Correct.
Okay. Are you familiar with the National Abortion Federation?
I am familiar that this entity exists. I'm not a member.
Okay. May I? A. Is this for? May I approach, Your Honor?
You may.
So could you please take a look at Exhibit A? There's a tab for it. And in particular, I would like you to first look at the first page of A. And then take a look at page 16. And the page numbers I'm referring to are the ones at the bottom where it says intervening defendants Exhibit A, page 11 of
What page are you on, Counsel?
16, Your Honor.
Thank you.
Do you see standard 2.1?
I do.
Okay, and you see it's under informed consent?
I do.
Okay. And that standard reads, the practitioner must ensure that accurate information is provided about the abortion process and its alternatives and the potential risks and benefits. I read that correctly, right?
You did.
All right. Would you agree that this standard is consistent with the standard of care?
I do.
Okay. Would you agree, or you do agree, right, that it should be applied in virtually all cases and that deviations would be rare and difficult to justify?
What I will say is, when I was talking about the standard of care, I said the standard of care must take into account guidelines. So this is one of those guidelines. And then tailor those guidelines to your patient specifically. So if this informed consent standard here was taken and applied to the patient in their specific circumstance, yes, that would be consistent with the standard of care.
Okay, so do you then in fact disagree that it should be applied in virtually all circumstances and that deviations would be rare and difficult to justify?
I think the nuance here is that this should be tailored. So for example, the practitioner must ensure that accurate information is provided about the abortion process and its alternatives. The alternatives could be different in different cases. So this is too broad to apply verbatim to your patient. This actually must be nuanced. It has to be nuanced.
So it's not a standard then?
It is a standard that then needs to be further nuanced and tailored as you deliver it to your patient. No one is just reading this line and adhering to it in one specific way every single time. This allows for tailoring.
So am I correct to understand that it is not true in virtually all cases that the patient should be informed of alternatives?
No, the alternatives could be different in different cases. So
Understood. Yeah, agreed. Yeah. So,
So
but it's
this-
true that in every case, they should be told of alternatives.
sure, yeah.
Okay.
But if I may I?
Well, no,
Okay.
you've answered my question.
Okay.
I do have a number of them and I'd like to move along.
Okay.
Would you agree that this standard is consistent with the standard of care, right?
If it is tailored to your patient, correct.
But the tailoring you're speaking of is just mentioning that the alternatives that do in fact apply to the patient.
Not just the alternatives. The potential risks and benefits are different based on your patient's individual circumstances. So for example, if you have someone with a bleeding disorder, the risk of bleeding is higher than for someone without a bleeding disorder. So all of this must be tailored. It's not that it can be tailored, it in fact must be tailored.
I understand. So you're saying that when it says risks, benefits, alternatives, those have to be risks, benefits, alternatives to the patient.
Correct.
Okay. And so long as those risks, benefits, and alternatives are to the patient, specific to the patient, then it's not a burden on the patient.
Correct.
And it would in fact help them to make and effectuate decisions related to pregnancy, correct?
It would help them to make any health decision. Yes, if you are following this standard of care in general,
Including reproductive health decisions.
including reproductive health decisions.
Would you agree that this standard represents the best practices for abortion providers?
Yes, again, if it's tailored.
Would you please look at option 2.1.0.1? Do you see that? It's right under standard 2.1.
Yes.
And this option states that information may be provided either on an individual basis, in group sessions, or with appropriate patient information materials, and can be done in person or remotely. Did I read that correctly?
You certainly did.
Okay. Would you agree that this option is consistent with the standard of care?
Again, yes, but must be tailored still.
Hence the appropriate patient information materials.
Correct.
Okay. You don't object to patients being provided information materials generally, do you?
Absolutely not.
Okay. Can we look at standard 2.2? And this standard states documentation must show that the patient affirms their decision to have an abortion and that their decision is voluntary and that they are aware of the potential risks and benefits of the abortion procedure. Correct?
Correct.
All right. And again, you agree that this standard is consistent with the standard of care, right?
Correct.
You agree that it should be applied in virtually all cases?
Once tailored, yes.
What needs to be tailored?
The potential risks and benefits of the abortion procedure.
Okay. You are familiar with the American Medical Association, right?
I am,
Known as the AMA.
yes.
In fact, I do believe you provide a peer review service for their journal. Is that correct?
I do.
Okay. Are you familiar with their medical code of ethics?
Yes,
Okay. Do you endeavor to follow the AMA's code of ethics in your practice?
I do.
Okay. You agree that the AMA's code of ethics is relevant to public health in Michigan?
I do.
Okay. Can you turn to exhibit B? Exhibit B in your.
B?
Yes, please. Do you recognize exhibit B?
I do.
What is it?
It is the AMA Code of Medical Ethics.
For informed consent, correct?
Correct.
It's just this one page.
Yep.
All right. Do you agree that, can you briefly review it? I mean, can you tell what it is by looking at it?
I can.
Yeah. Do you agree that this is an accurate and complete copy of the AMA Code of Medical Ethics 2.1.1?
In order to make sure that it is verbatim accurate, I would need to verify that with their website, but I will take your word for it.
Well, I'm not asking you to take my word for it, but we can assume for the purposes of my questions that this information is from the AMA code.
If you were asking me to assume, then I will.
Yeah, for the purposes of my questions.
Okay.
All right. So in this code of ethics, you'll see it subsection B. The code states that for informed consent, the physician should include information about a diagnosis, if known, the nature and purpose of recommended interventions. You see that? I'm sorry, is that a yes?
That's a yes.
Okay. And the burdens, risks, and expected benefits of all options, including foregoing treatment. Do
I
you
see that.
I'm sorry?
I see that.
Okay. Do you have any reason to disagree with this statement of medical ethics?
I would have preferred that the word relevant was in there.
Instead of, or in addition to?
The burden, risks, and expected benefits of all relevant options. I think perhaps the AMA is assuming that as physicians, we are thinking of this as all relevant options.
Okay. So just to be clear though, the word option here includes alternatives, correct?
It does.
Yeah.
But it should not include irrelevant options.
Okay. So isn't it true that surgical or procedural abortion is an alternative to medication abortion?
It is true. However, there are some circumstances where one option is not available for a given patient, given their medical history, their comorbidities, their medications, or other reasons.
But it is generally an option.
Generally.
Okay. So, but to be clear, someone who is seeking an abortion could make a choice between medication abortion and surgical abortion, provided that the surgical abortion would work for them or the medication abortion would work for them, correct?
This is where that idea of tailored medical information is really important, because there are some cases in which one option may not work for a patient, but in general, yes.
Okay. So this statement about the burdens, risks, and expected benefits of all options, including foregoing treatment, that's in Exhibit B. This statement's not a burden on patients, is it?
If we are talking about relevant options, which I think the AMA is assuming here.
It's not inconsistent with the standard of care, correct?
It is not inconsistent with the standard of care.
In some cases, foregoing treatment is an option, correct?
Correct.
And a patient can change her mind at any point during the informed consent process, including immediately before the treatment, right?
Absolutely.
And if the patient forgoes an abortion, pregnancy will more likely than not continue, correct?
Again, this is where we have to really think about the situation, the patient's specific situation. If we are talking about a viable pregnancy, the alternative could be to continue that pregnancy that could result in childbirth. If we are talking about a non-viable pregnancy, the alternative could be a pregnancy that does not progress and a woman, for example, developing sepsis because her procedure is not done. So in general, yes, but it's not always correct given a patient's specific medical circumstances.
But that's why my question was phrased as more likely than not. My question is, if a patient forgoes an abortion, the pregnancy will more likely than not continue, correct?
Correct.
Okay. And if the pregnancy continues, birth is a possible outcome, correct?
Birth is a possible outcome,
Okay.
correct?
And if the patient gives birth, then her options are parenting or adoption, correct?
Correct.
It's not necessarily inconsistent with the standard of care to provide information about foregoing treatment or other options, even if the patient is sure she wants treatment, right?
No. However, what really matters here is context. So telling a patient that your pregnancy may continue and you may deliver a baby is very different than providing information on breastfeeding, safe sleep, not smoking around a baby. And in fact, providing that type of information is irrelevant when as yet there is no infant.
Isn't it? So isn't it true then that you believe that a patient seeking an abortion should be provided tailored information based on what the physician feels is relevant, correct, pertinent, and applies to the patient in particular case?
Yes, as well as what information the patient asks for.
Okay.
So this is really a discussion.
So isn't it true that there are some cases where a doctor can recommend a patient choose a different intervention than what the patient is seeking?
Yes,
Okay. And a patient cannot ask about alternatives the patient doesn't know about, right?
correct.
Okay. And a patient may incorrectly believe that an alternative is unavailable and so not ask about it, right?
I don't think any pregnant woman doesn't know that continuing a pregnancy is one alternative.
But it's possible, right?
I cannot imagine a universe in which that is possible.
Okay. But if the alternative is parenting and they believe it's not possible because they don't have the financial means to do it, they could choose not to ask about it, correct?
If a patient doesn't have the financial means to continue with a pregnancy, and that is their reason to terminate a pregnancy, that is their choice.
I'm sorry. So if there was a patient who was told if she has the baby, she's going to be kicked out of her boyfriend's house. And so she doesn't realize that there's housing assistance. And so she thinks her only option is to get rid of this baby so she can stay at home. I'm sorry, I'll say terminate the pregnancy. I'll just speak of it in that terms, right? Isn't it possible that she would not know to ask the doctor about options involved?
If there was a situation in which my patient was struggling with housing instability, it would be my duty to provide them with whatever resources I could find on appropriately finding housing resources. Now, if this was someone who was coming to me with a non-viable pregnancy, for me to provide them with information on safe sleeping and breastfeeding, I can find no reason for that other than to be cruel. So I'm not.
Do you know the rate of non-viable pregnancies in the state of Michigan?
Not off the top of my head.
Okay. Do you know if they're more likely than not?
The miscarriage rate is higher than many people think.
Understood, but I asked about non-viable pregnancies.
I don't know that that's relevant here. I think we're talking about providing information that is tailored to an individual. And what's legislated is providing information that may not be relevant to a patient. So a healthcare provider's role is to provide all information that is necessary, that is needed, that is relevant to that patient's situation. But in situations where it is unnecessary, irrelevant, or even cruel to provide information, I think it is that healthcare providers' responsibility to be cognizant of that fact and make a decision that actually makes sense.
Okay.
The legislation undermines that decision-making.
Okay. I understand. I do ask, though, that you keep your answers brief. I'm asking primarily yes or no questions, and there are a number of them.
Okay.
Okay. So you stated that all information should be relevant to the patient's goals, correct?
They should be tailored and relevant to the patient's goals, correct?
All right. And those goals can change over time, correct?
They can.
And they can change, those goals can change with new information being presented, correct?
Yes.
And we should provide that information to see if it's relevant, correct?
No, you're not providing information to see if it's relevant. You're having a discussion with a patient. You're determining what is relevant, and then you are providing the appropriate information.
I'm saying generally speaking, the informed consent process should include possible alternatives so that the patient can decide whether it's relevant to her.
You would involve possible alternatives as deemed relevant by your clinical history, your interaction, and your medical judgment.
So if a patient does not affirmatively ask for information, can't the doctor nonetheless provide the information in case a patient might be interested in it?
Absolutely, based on that medical provider's best judgment.
Okay. Surely the state can make a patient aware of alternatives and options to medical procedures, correct?
We often make people aware of alternatives with a website and other educational materials, but it's never legislated the way that these are legislated and mandated.
Okay. So if you have a breast cancer patient that's seeking a double mastectomy for stage 1 cancer because they're overly concerned about the cancer, wouldn't it be within the standard of care for the doctor to mention that she can wait to see how the illness progresses and whether chemotherapy might work?
I'm sorry, you're saying in all cases where someone is desiring a double mastectomy, you should.
No, I'm sorry. I'm giving you an example. My understanding is you're here to provide your expert opinion, and I want your expert opinion on what that hypothetical.
Okay, could you repeat the question, please?
Yes. If you have a breast cancer patient that's seeking a double mastectomy for stage 1 cancer because she's overly concerned about the cancer, wouldn't it be within the standard of care for the doctor to mention that she can wait to see how the illness progresses and whether perhaps chemotherapy might work?
So I love that you asked this question because it shows how this information must be tailored and nuanced. If that woman carries BRCA1 and BRCA2 mutations and has a strong family history of breast and ovarian cancer, then maybe a double mastectomy would be good for her. So this is why tailored information is so key here.
But you would have to do further tests to determine that genetic makeup, correct?
That testing may have already been done.
But it may not have been done, correct?
I really don't understand this hypothetical. If you have a patient in front of you who is coming to you with a family history of breast cancer, you've already elicited this. You have a strong suspicion that they may carry BRCA1 and BRCA2.
No, ma'am, that's not the hypothetical. I'm sorry. No, doctor, that's not the hypothetical. My hypothetical, say she discovers it on a mammogram and there's a lump and the patient is overly worried. There's no further testing. She walks into a doctor's office and says, I can't take it. I want a double mastectomy. The doctor can tell her, hold off, right?
The doctor can tell her to hold off depending on that whole risk scenario. It depends on her family history.
So,
It depends on a variety of other things.
so it's a possible option that should be told to her, correct?
I really don't understand this hypothetical because in some cases, you may not be trying to, can we do a different hypothetical? I just don't feel comfortable
What
with that
about
one.
opioids?
Yes,
If a patient comes in asking for opioids, their goal is to get opioids. That's what they want because they know they've worked in the past.
yes,
A doctor can explain to them other options that are not opioids, right?
absolutely,
Okay, even if he doesn't ask about them, even if the patient doesn't ask about them.
absolutely.
Okay, and that's completely in keeping with the standard of care.
Completely in keeping with the standard of care.
And
But
it's not a burden.
it's not a burden, but the
Okay.
alternatives are very patient dependent. So if, for example, that patient is coming to me with some lower back pain, yes, I've got so many alternatives for that. If that patient is coming to me with metastatic pancreatic cancer and they are end of life, then opioids absolutely could be the best option.
So isn't it true that there's a threshold of information required to ensure that a patient is duly informed?
Yes, but my point is that that must be determined by the patient-physician interaction and not legislated.
Is it in your practice, does a doctor know everything about every patient?
No, but it's your duty to take a clinical history to the best of your ability and to
And-
review the patient's
and-
chart.
And what if the patient lies on their clinical history? Or what if the patient refuses to provide a clinical history?
That is a limitation. But I'm not sure how it's relevant.
Isn't it true? Isn't it true that a doctor could have their own biases in the informed consent process?
It is possible.
And these could be known biases that the doctor could correct for. Right?
Tell me what you mean by that the doctor could correct for.
Well, an example might, I'll have to do my best not to testify here, but my hypothetical would be a situation where there's a doctor who's only ever used one treatment and so always recommends that treatment. He could correct for that bias towards that treatment by making sure that he tells other doctors or the patient about other treatments, right?
Sure.
Okay. And these biases could be that doctors have, they could be financially motivated, couldn't they?
It is possible, although it is unethical. I guess it's always possible for people to practice their profession in an unethical way.
Yeah. And this happened with the opioid crisis in Michigan, correct?
There were cases where this happened, correct?
Isn't the right to know alternatives and options implicit in the right to make and effectuate decisions about all matters relating to pregnancy, including but not limited to prenatal care, childbirth, postpartum care, contraception, sterilization, abortion care, miscarriage management, and infertility care?
I love this question because I like how you have applied this equally to all these different types of healthcare, which are all healthcare. So why is it then that we only legislate and mandate information on one of those topics, and that's abortion?
So is it not possible for the state to mandate information in an area where they think it's necessary and not mandate it in an area where they think the public is getting adequate information?
I don't,
Objection. It's calling for a legal conclusion.
I'm sorry, I'm asking in her opinion, is it not okay as the chief medical executive of the Department of Health and Human Services?
I'll allow it.
I don't know why the legislature would think that this is an area in which there is a lack of information. I'll tell you where there's a lack of information is antibiotic prescribing. Should we mandate laws around antibiotic prescribing for physicians? Because that's an area where
Ma'am, I'm sorry. I want to put on the record, I have a very bad habit. I was in the Army as a JAG officer for several years, and I'm taught to say sir or ma'am to every superior. So it's an automatic response. I acknowledge that the honorable witness here is a doctor. And so, but my question, Dr. Bagdasarian, is it okay for the state to do this? I'm not talking about the legislature. I'm talking about the state, and the state includes its agencies such as the Department of Health and Human Services. Can the Department of Health and Human Services provide information in an area of medicine where it thinks it's lacking and not provide it in an area where it thinks it's adequate?
legally, these entities, the legislature can do whatever they want to do. They have enacted these laws. However, why is it that we mandate certain types of information and then mandate that it is reviewed only in abortion and not in other types of healthcare?
Okay, but again, my question involves the Department of Health and Human Services. Is the Department of Health and Human Services allowed to do a public awareness campaign for one area of treatment where it thinks information is necessary and ignore all the other options? Like, for instance, I'll give you a hypothetical, or I'll ask you a direct question. It's possible for the DHHS to decide to do a public outreach campaign and provide information on opioid abuse and not other abuse, correct?
Yeah, for sure.
Okay.
However, the difference, and I mentioned this to the other attorneys, is that when we're providing information about substance use disorder, we're saying, here's some resources, talk to your healthcare provider. And it's on them to get tailored information from their healthcare provider. I cannot think of another circumstance where someone already has a healthcare provider, they are already being managed by their healthcare provider, and then we are inserting ourselves in the middle of that relationship.
So the answer to the question was yes?
I don't even know what the question was anymore.
Okay, I would ask that you keep to the question.
I will do my best.
The other attorneys will have an opportunity to
Right.
redirect
Thank you so
and
much.
elicit these kinds of responses. I'm looking for very specific answers.
I'll do my best.
Please do. Isn't it true that patients often look up medical information on the internet?
Absolutely.
And doctors have to be able to explain whether or not that information the patient found on the internet is applicable, right?
Correct.
Isn't it true that the purpose of informed consent is the patient's liberty interest? It's ensuring autonomy.
Please repeat.
The purpose of informed consent is the patient's liberty interest. It's to ensure their autonomy.
It is to assure their autonomy. I don't know that I've heard the word liberty inserted into this particular type of conversation, but yes, it is to ensure patient autonomy over their body.
And you agree that a patient can only provide informed consent if consent is informed, knowing, and voluntary.
Yes,
And it's a basic human right not to have a procedure performed on you unless you consent, right?
correct.
And isn't it true that the point of informed consent is not patient certainty?
Can you expound upon that?
Well, the goal of informed consent is not to make sure that the patient is certain of their decision, right?
The goal of informed consent is to make sure the patient understands and agrees to and consents to the procedure. I'm not sure what you were asking.
Well, a patient can be uncertain about the procedure, yet still provide informed consent, correct?
Can you distinguish the term certain from consent? What's the difference between, in your opinion?
Well, a patient can not be certain that it was the best choice to make yet nonetheless consent to the procedure, correct?
In informed consent, there is a discussion that you're having with the patient, and the goal is to help them make the best choice for themselves. So I don't understand the distinction between those two terms that you're trying to make here.
Well, I'm just talking about the patient's certitude. Not the best choice they have to make, but whether or not they're certain about the choice. Is that even a metric you use to determine if consent was informed and voluntary?
I still don't understand how you're trying to separate certainty from consent. Can someone else?
No, unfortunately, no. I'm all here, up
Okay.
here on my own.
I,
Well, let's put it this way. You're familiar with Henry Ford, correct? The man who made automobiles?
sure.
Are you? Do you know of him?
I know of him. I
Yeah.
don't know a great deal about his life.
Okay. Are you familiar with him enough to know that he made the Model T?
I will take your word for it.
Objection. What is the relevance?
The relevance.
Detroit's history, like.
I didn't study this in medical school.
Okay, I'm going to allow it just because I think he's trying to give an example of between certainty and consent. And I think this is how he's trying to bring that about. So I'll give you a little bit of leeway, but get back to the relevant information, please.
I'm also enjoying learning about Henry Ford.
Thank you, Your Honor. So you may or may not have known, but it is reported that Henry Ford said of his car, the Model T, that the customer can have any color as long as it's black. Now, my question to you is, those customers of the Model T were pretty certain about their choice of black, correct? You would think?
They didn't have a choice.
So in order to have a choice, you have to have options?
Objection.
Yeah, Counselor, I think we're gonna have to not ask the doctor about questions about the Model T. Yeah. Get it back on track to what we're here about. Please.
Yes.
Thank you.
You're trying to say that if
May
you.
I ask another question?
Okay.
So is it correct then that in order to have a choice, you have to have options?
If we are talking in generalities, then yes.
What does it mean to be talking in general? I mean for a clinical medical choice, do you need options in order to actually have a choice?
Okay. Yeah.
The point of informed consent is accuracy of information, comprehension, and voluntariness, right?
Correct.
And this is exactly what the Reproductive Freedom Amendment requires, so that the patient can make and effectuate decisions, correct?
Is the Reproductive Freedom Act the law that we're here today to discuss? Is that the other name for it?
It's one of them, correct?
Yeah.
No, to be clear, just so there's no misunderstanding, I will retract the question. We'll move on. So to be clear, the law that we're discussing, that you discussed on direct, it is alleged that that law contradicts or is in violation of the Religious Freedom Amendment. So I withdraw my question. This may sound like a self-evident truth, but a patient cannot know what she doesn't know, right?
Correct.
Right. And a patient cannot know if she wants an invasive treatment unless she knows all the benefits, burdens, and risks associated with the treatment and all the alternatives, including foregoing treatment, correct?
All the relevant alternatives.
So throughout this litigation, you've used the term medically inaccurate to information when describing DHHS's materials, right?
No. I have said either it could be irrelevant or inaccurate.
Okay, So, but you have used the term medically inaccurate information?
I have said it could be medically inaccurate for some people.
Okay, that was my question. When you use the term about medically inaccurate about this information, you don't mean that it contradicts a medical textbook. You mean that the information is not necessarily relevant to a patient's particular circumstances,
It
right?
may either be irrelevant or for a particular patient, it could be inaccurate. So it's not inaccurate across the board. DHHS has tried to do the best that they can under the current legal statute. However, we know that this information is irrelevant or inaccurate for some patients.
But that would necessitate that it's relevant and accurate for other patients, correct?
Correct.
Right.
And I'm talking
and,
specifically about the fetal pictures. I am not talking about the parenting packet. That information I do think is irrelevant for anyone who is asking for a pregnancy termination.
What about a patient who is trying to decide between an abortion and parenting? Would it be relevant to them?
I gave this example in my deposition. So if you are talking to a cancer patient about their options, perhaps their options are chemotherapy or no chemotherapy. And if they have no chemotherapy, there is a risk of death. You don't necessarily have to then describe what their funeral arrangements might look like, because that is irrelevant. So if someone is deciding between terminating a pregnancy and continuing the pregnancy, I still don't believe that it is relevant to talk about an infant that doesn't yet exist and infant safe sleeping habits or nutrition.
Ma'am, Dr. Bagdasarian, could you go to Exhibit 4 in the small binder, please? Please go to page 29. You see on page 29, it starts with prenatal care, correct?
Correct.
And so a patient who is trying to decide between an abortion means that, I'm sorry, a patient who's seeking information about abortion because she thinks she's going to have an abortion implies that she is currently carrying a child, correct?
Carrying a fetus or embryo.
Sorry, a fetus. Yeah. Oh, correct.
Correct.
So, if she's trying to decide between abortion and parenting or letting the fetus come to term, then if she chooses not to have an abortion, then she, at that point forward, does prenatal care, correct?
Correct.
So for someone trying to determine whether or not to carry the child or terminate the pregnancy, some of this information is in fact relevant, correct?
Some of the information, the vast majority of it is not relevant.
And if there is a patient trying to understand whether or not they could in fact parent an infant, and if they had that information, may decide to parent, that information would be relevant to their decision, correct?
In my experience, most people who have already made a decision and who are seeking termination have already had multiple conversations with family and with friends and have already sought out this information in a myriad of other ways.
So are you saying it's okay for the doctor to assume that they have the information?
No, I think it would be okay to ask if they need any other information in order to make their decision. I think that giving a standard set of documents, mandating that someone reads it, and then signing a form to say you read it is, I think that's what's causing the harm here.
Ma'am, it's not your understanding of the law that the doctor, I'm very sorry. I truly mean this. Dr. Bagdasarian, it's not your understanding of the law that the doctor has to stand over the patient to ensure that they read the material, is it?
No, but they have to get a signed form stating the patient has received and reviewed this material.
And the patient can look at the pages and decide it's not relevant, correct?
Why are we putting that burden on a patient?
But that is correct, right?
I guess it depends on their comfort at signing something that isn't true. So if they are saying that they've reviewed something, it depends on their comfort level for them to decide to sign a form when they haven't reviewed the material. I just don't know why we're putting this burden on women.
In your practice, do you make sure that a patient reads every rule of every word of an informed consent form?
I don't, but I also don't typically give them pages and pages of irrelevant information and then ask them to sign a form saying they've received and reviewed it.
Nonetheless, though, a patient could choose to review it by glancing at it and throwing it in the trash, correct?
That's sure.
And a patient who's using the website could choose to simply click through the web pages, get to the end, and execute the confirmation page, correct?
If that is the burden we wish to put on women in this situation, then yes.
Okay, it's correct. They can do
It's
that.
correct, they can do that.
Okay. Now, you've testified that is in keeping with the standard of care for a physician to provide information that the physician thinks might be relevant, but is not sure is relevant, correct?
They can either provide information that they think could be relevant, or they could have a conversation to best determine whether or not it is relevant.
You've testified that it's in keeping with the standard of care for a physician to explain what happens in the majority of cases and then explain to the patient how her case is different, correct?
Correct.
And as you said previously, that a doctor has to use their best judgment to account for the possibility that the patient hasn't been forthright or provided a complete medical history, right?
Correct.
Now, isn't it true that you believe that even correct information on alternatives is biased or coercive because it could steer someone towards a certain outcome or decision that may not have necessarily been the choice they otherwise would have made for themselves?
Correction. I think that medically correct information can be biased or coercive depending on how it is presented and in what context.
Isn't that a problem, though, for a doctor to presume that a patient should not have even correct information because it may result in the choice they otherwise wouldn't have made for themselves?
No. I think when you are having a conversation with a patient, if I am having a conversation with a patient and they are, for example, sobbing in my room because they have a non-viable pregnancy, if I were then to give them medically accurate information on breastfeeding, that is simply cruel. So you can provide medically accurate information in a way, in a context that is so irrelevant as to be cruel, coercive, manipulative, cause guilt. That can all be done. You have to read the room. You have to work on that rapport that you have with your patient.
So, but isn't the entire point of informed consent to provide information that informs the patient's choice?
Absolutely. But what I'm saying is,
That's good. I'm sorry.
Jessica, can you please just not interrupt the witness?
Let's just continue. Thank you.
You agree that a doctor can use a standardized informed consent form if the doctor reviews it and determines that it's appropriate, correct?
Correct.
And that's including a form that the doctor uses for every patient, correct? For their particular treatment, correct?
My experience is that there is almost always an area where a healthcare provider can add information and can delete information that is not appropriate.
And you testified, I believe, that DHHS provides broad information and then they tell the patient to go talk to their healthcare provider. Isn't that correct?
For the most part, yes.
Can you take a look at page 4 of page 6 of exhibit 4? And page 6 is the medication abortion information, correct?
Correct.
And if you look at the third paragraph under the very first heading, medication abortion, doesn't this in fact state you should speak with your provider for more detailed information about the specific regimen that is right for you?
It does.
So isn't this an example of providing broad information and then telling the patient to go speak to their provider?
Except for we are mandating this information, even if you already have a healthcare provider, you've already discussed this extensively, then that healthcare provider has to tell you to go and review this information on a website or print it out, including information that may not be relevant to you. So the difference here is usually we provide broad information and then ask people to go to their healthcare provider. This is happening even if you have a healthcare provider. The healthcare provider is sending you back to the website. You have to review all this general information that you may not need. It may not be relevant to you. It may be, in fact, inaccurate to you, and continue on your path with your healthcare provider.
Is it, doctor, is it your understanding of abortion services in Michigan that the patients maintain a patient-provider relationship with them?
No, I'm talking about cases in which you have an OBGYN who you've been following with, and you end up with either a non-viable pregnancy or a health risk where you have to terminate the pregnancy. In those situations, you already have a provider relationship. You already have someone you're following with, and that individual still has to send you back to DHHS to jump through all these hoops, even though you are already consulting and receiving information that's appropriate for you.
But doctor, isn't it true that the vast majority of abortions are performed by providers who don't have a pre-existing doctor-patient relationship with the patient?
I would say that the majority of abortions are provided in that manner. However, my responsibility is to all the women of Michigan, including those with non-viable pregnancies or pregnancies that are that include significant health risks.
You yourself have given patients pre-printed brochures and papers, correct?
Only when I have determined that they are appropriate, relevant, and best for that patient.
I'm sorry, doctor, is that a yes?
Yes.
All right. Isn't it true that the challenge laws do not prevent a doctor from providing more tailored information than the required disclosures, correct?
Can you say that again?
The law at issue here today that you spoke on, it doesn't prevent a doctor from providing more tailored information than the law requires be disclosed.
But it doesn't allow them to omit information that is inaccurate or irrelevant for that patient.
But that, the answer to my question is,
Yes,
so, isn't it true that you've testified that standardized consent forms can be used to help establish a baseline for informed consent discussions?
yes,
And that's a true statement, correct?
yes. I have not testified anything that is not true.
Thank you. I didn't assume that you had. I just, for the record, my question could have been read as that those words came
Yeah,
out of your mouth.
Just keeping you on your toes.
You're doing a good job,
Thanks.
doctor. You testify the informed consent is more than just a form, it's a process,
Yes.
right? And the process includes patient counseling, a conversation, right? Questions and answers with the medical provider, consideration, and the consent form, right?
Yes.
And the challenge laws don't replace Northland's consent forms, right?
Correct.
Right. In fact, what the challenge laws actually require is patient education material. Isn't that true?
Correct.
Right. And you just believe that the state shouldn't provide these educational materials, right?
No, I believe that it should not be mandated.
Okay. But some of the department's programs include creation of medical literature meant to be read by patients, right?
Of course, but none of that is mandated.
And some of that information the department is required to develop and make available to patients under the health code or regulations, correct?
Correct.
All right. Are you aware that under MCL 333.9131, the department is required to publicize places where family planning services are available?
May I see that statute?
Are you aware, I'll withdraw that question and ask it more specifically. Are you aware of, or more generally, are you aware of any law in the state of Michigan that requires the department to publicize the places where family planning services are available?
I would need to review the law specifically, but I can take your word for it.
I don't, please, doctor, don't take my word for it. I don't, I'm looking for your knowledge.
Yeah, I'm not a legal expert. I would be happy to review any legal statutes that you'd like me to review for you.
Okay. Are you aware of any law in Michigan where the department is required to publish a standardized written summary of various patient disclosures for end-of-life care?
I am not aware of any law where we have to publish a standard set of material that people are mandated to review in any circumstance outside of abortion. If I'm incorrect, please correct me.
Again, I want to be very specific about my question because I think perhaps you misunderstood. I only asked if you were aware of a law requiring the department to publish a standardized written summary of various patient disclosures for end-of-life care, not mandate them, but publish them and make it in a standardized pamphlet. Are you aware of any laws?
Maybe this covers both questions. There are many circumstances in which the department is asked to create educational materials on a variety of subjects, which we do. I cannot think of any other circumstance where individuals are mandated to review that material.
Right. Your Honor, at this time, intervening defendants make a proffer of Exhibit Q. Actually, it's already been established that it's one of our exhibits. It's been provided to the court, but I do have another copy. May I approach, Your Honor? So, Your Honor, this document was produced by Defendant Director Hertel in response to intervening defendant's request to produce number 11. Now, to produce number 11, it's stated, produce all documents and information that MDHHS has developed, adopted, approved, or promulgated, published, or made available in accordance with MCL 333.5656. The response was MDHHS is producing all relevant materials. This is a pamphlet issued by a public authority and it's self-authenticating under MRE 9025. And therefore, intervening defendants move to have it admitted into evidence.
May I respond, Your Honor, since it's an evidentiary issue outside the scope of the witness? They cannot rely on intervening defendants are defendants with Director Hertel. They can't rely on her request for admission. The rules of evidence require that it be an opposing party statement. They are not an opposing party. They are both defendants here. So that foundation is not the necessary authentication. There is nothing on the exhibit that has been produced that provides the indicia of reliability as to what this is. It's not an official government record. It looks like it's a printout. The way they're trying to establish the Government Records or Business Records Foundation, Public Records Foundation is through an RFA, which they cannot use because it's not an admission of a party opponent. And the state law and the rules of evidence are very specific about how that works.
May I respond, Your Honor?
Okay.
Yes. Well, as for indicia of reliability, the second page of Exhibit Q does have the stamp of MD, the Michigan Department of Community Health. It also has other indicia of reliability throughout it. As to the claim that we cannot rely on it because Director Hertel is also a defendant, I believe the court is well aware of the diametrically opposed stances between the state of Michigan defendants and the intervening defendants. So I don't think that particular instance it should apply.
Your Honor, you were directed to page 2. Page 2 shows that Jennifer Granholm was the governor when this is published. So it's clearly not current material from the website. It's multiple documents combined into one. There is no information about what website they came from, where they are, whether this is a website maintained by DHHS, whether it's current material, prior material, material that has been removed, updated, or changed, whether this material all comes from the same place. It appears to be multiple documents stapled together with no date, no idea where they came from. And Dr. Bagdasarian, as the chief medical executive of the state, has said she's not familiar with this material, so she can't provide that foundation. I think the documents on their face don't provide the indicia of reliability. They in fact provide indicia that they're not reliable and not current. And we would object to their admission under those evidentiary rules, Your Honor.
Your Honor, I think it's pretty clear that the first page is a pamphlet. That's a trifold.
But Your Honor, that's not evidence.
I'm sorry.
I'm sorry. Counsel's saying this is pretty clear. This is what it is.
Let him just finish his argument and then I'll give you a chance to respond again.
There's no requirement that the official pamphlets be reproduced and reprinted with the current director every time the director changes. Not that I'm aware of. I think it's rather standard that you publish a bunch, you print them, you pay for it, and you don't update it until you need to print more or the information changes. The first page is a trifold. The second page is a standard pamphlet.
Mr. Fetal, if you can just go through for me what you think that the indicia of reliability on these are, on this pamphlet is.
Okay. The first page is a trifold and the indicia of reliability is on the second page. What would be on the back of the trifold pamphlet is a stamp from the Michigan Department of Community Health.
You know what? I'm going to take a short 15-minute recess and review this document and rule on the evidentiary issue afterwards.
Can I just put one other thing on the record, Your Honor? Page 2, if you actually look at the fine print, I apologize, I'm getting old and don't have reading glasses. It appears to say 7-03, which means it's more than 22 years old.
We'll take a short 15-minute recess.
All right,
Thank you.
Thank you.
Or will now reset. the Michigan. Now, so
Sorry, I misread what message was supposed to be. We're gonna recess until the rest of the defendants are back. I think we're missing a few. Sorry about that.
Right. I'd like to make a motion.
Welcome back. Thank you. May be seated. Took a look at this document, Mr. Tuttle, and I think we had spoken before, and you said that you have the ability to connect your computer and to the internet and show exhibits up on our screen there.
I believe that was, we do as a team. Yes,
How
Your
about
Honor.
we do that? Because then we can see whether these documents that are being cited by as documents from the MDHHS are available on that website.
Oh,
That would be self-authenticating.
Your Honor, I do believe that the only one that would be available on the website is the last section. And I would like to modify my request actually and just have the first 2 pages admitted and disregard the remaining ones. Because I do see it is multiple documents. And we're primarily concerned with the trifold pamphlet that was produced by MDHHS. So it'd be the first 2 pages.
Yeah, Your Honor, we have an objection. It's a document that's dated on its face, 2003. There's no evidence of what the laws, requirements, practices were of DHHS. It's not relevant to the claims at issue here, we don't believe, and the document doesn't authenticate itself.
Your Honor, I do believe it clearly falls within the self-authenticating rule because it is a document produced by.
I think if you can pull up this document on the MDHHS website for me, then it would be self-authenticating. But just based on what I have in front of me, I don't know. So if you want to make that attempt, that'd be
Okay.
great.
Your Honor, given that it's noon and we've been going for some time, perhaps now would be a good time to take a break and we could set that up, or do you need it right now?
I would really prefer to finish Dr. Bagdasarian's testimony before we break for lunch, if that is something that we can do.
I believe it will be a couple more hours, Your Honor.
Dr. Bagdasarian's testimony is going to be a couple more
Well,
hours.
yeah, I have a number of questions, but most of them are eliciting very long answers, Your Honor, and that's taking quite some time.
How long do you think it'll take you to get the website up on the board?
Pull it up right now, if you can tell me the website address.
It's very long. I will just say that I have pulled it up, so I know it exists. And I'm
Okay.
giving you the opportunity to pull it up and ask your questions in a way that it is self-authenticating. And what I did was Google the Michigan Dignified Death Act.
Your Honor, based on your representation that you Googled it and found it on the website, I similarly Googled it. And rather than further extending, I would ask though, Your Honor, if this is really going to be a couple more hours, we all have flights home tomorrow. We've already, rearranged. We can't stay at our hotel. So if the intervening defendants are truly intending to spend several more hours with Dr. Bagdasarian, we will not finish on Wednesday. And we need to make arrangements to find a place and to find clean clothes because we don't have that. So I would just ask if we could right now confirm with Mr. Tuttle if his a couple more hours is like genuinely a couple more hours. And we're going to go into Thursday and Friday, so we can try to make some arrangements so that we're not all trying to sleep in the lobby.
Okay, so I want to be very careful in allowing everyone the time that they need to conduct the trial in the way that they see fit. How about if we continue with Dr. Bagdasarian's testimony and see how long that takes, and then make any plans according to that, based on that timeline?
I appreciate that, Your Honor.
Okay.
So, Your Honor, am I to understand that document or Exhibit Q is admitted?
Pages 1 and 2 of Exhibit Q is my understanding, Your Honor.
Yes.
Okay.
Page 1 and 2 of Exhibit Q.
Okay. So continuing on with the questioning, Dr. Bagdasarian, if you could take a look at Exhibit Q in page 1. Do you see where it says information about other medical treatments and their risks? Do you see that on the left side?
I do.
And do you see where it says, it looks like the first bullet point under that list, your doctor must tell you the reason for this recommendation. Do you see that? Where it says, I'll read the whole thing. This includes the treatment your doctor recommends. Your doctor must tell you the reason for this recommendation. Do you see that?
Sorry, where is that?
You're looking on the first page where it starts with Michigan Dignified Death Act. Do you see that? And then further down, it says information about other medical treatments and their risks. Do you see that? And then it says you have the right to be informed by your doctor about your treatment options. Do you see that? And then there's a number of bullets after that, correct? And this includes the treatment your doctor recommends. Your doctor must tell you the reason for this recommendation, correct? Is that a problematic statement?
I think it's broad enough and allows for enough nuance that it is not a problematic statement.
Right. What about the next one? Your doctor must tell you about other forms of treatment. These must be treatments that are recognized for your illness. They must be within the standard practice of medicine. Do you have a problem with that statement?
I don't.
And your doctor, the next bullet, your doctor must tell you about the advantages of the treatment. They must also tell you about the disadvantages and risks. They must tell you the same things about the other treatments you have talked about. Do you have a problem with that?
I don't.
Okay. Your doctor must tell you about your right to limit treatment to comfort care. Do you have a problem with that statement?
No.
All right. They must tell you about hospice. Do you have a problem with that statement?
No.
Okay. Those are situations, though, where a doctor must, where a state agency is stating that a doctor must say things, correct?
They are not requiring a mandated packet of information, as was implied when you first provided this packet.
I understand that. But again, my question, though, is this pamphlet from MDHHS is stating that doctors must state certain information, correct?
In a tailored way, because it specifically said they must tell you these treatments must be recognized for your illness. So I think that's the difference, is that this allows for tailoring and nuanced information versus the abortion material, which does not.
So the answer is yes, correct?
Correct.
Okay. So please, are you familiar with Laura's standing order for dispensing opioid antagonists?
Laura,
Yeah, sorry, I pronounced that incorrectly.
the standard order is under my name and signed by me. So yes, I am familiar with it.
Okay, are you aware that standing order states that pharmacists who dispense opioid antagonists under the standing order shall provide educational material approved by the Office of the Chief Medical Executive on the administration of opioid antagonists to eligible individuals?
I am.
Okay, so that is another instance in which the state is mandating that patients receive certain information, correct?
That is for pharmaceutical agent, the same way that when you are receiving any other pharmaceutical agent, it comes with provided information. Yes,
Are pharmacists medical providers?
yes.
Okay. Let's go to Exhibit 4, please. And specifically, page 16. And you see at the top, under the title Fetal Development, do you see where it states, below are descriptions of the various stages of gestational development? Note that fetuses may develop at different rates. The descriptions of fetal development are not intended to be complete. Do you see that statement?
Yes,
Okay. Isn't this an example of explaining what happens in the majority of cases?
it is.
Okay. Is this information doesn't prevent the doctor from explaining how the patient's case may be different, right?
It doesn't.
Okay. And the fetal development pictures in the DHHS material come from the CDC, right?
Yes,
And the text comes from what you have called an equally reputable source, correct?
yes.
Or reputable, I should say. Isn't it true that patients like visual aids in common comparisons,
Not always, no.
but some do?
Some.
Okay. Now, on direct, you testified regarding some questions during your deposition that I was involved in, correct?
Correct.
And you stated that it was and I have no issue with this, to be very clear. This is not meant to be confrontational in any way.
I did
But-
not mean to cause offense.
Yeah,
Also,
what?
I did not mean to cause
No,
offense.
no, there was none taken. I just want this to be clear, right? I just have a couple questions about that. Because you stated in a medication abortion, for a 2-week or even a 4-week fetus that passes, the literature explains that it's similar to the size of a poppy seed or a mustard seed, and a patient isn't going to see anything at that time, correct?
Correct.
But medication abortion is available up to 12 weeks, right?
Correct.
And according to the 12-week information on Exhibit 4, page 18, it says that the size of the fetus is about 2.5 inches long. And this size range is similar to a line, correct?
It does.
Okay, so it's true then that in some cases, not all, but in some cases, a patient who has received a medication abortion will pass fetal tissue that is visible.
If I may,
Yes, you may, Dr. Bagdasarian. To speed things along, though, it would be very good if you answered directly and then explained.
it is possible, but just from my clinical perspective and as a woman, if you are familiar with menstrual material and miscarriage material, it involves a great deal of blood clots, and unidentifiable tissue. And so for the vast majority of cases, you are just seeing clots and unidentifiable tissue. There is a misconception that you are passing something that looks identical to this picture. And I think you would be hard pressed to find a situation where you are passing something that is recognizable and looks anything like this picture.
Isn't it true, though, for abortion procedures that you have to ensure that all the products of conception are removed? And in order to do that, you have to examine what is passed?
No, that is not always correct.
but it's true in a number of cases, correct?
Typically, how we verify that all the material has been passed, if it's needed to be done, is with either an ultrasound or a beta HCG. Sometimes that is not needed at all, but usually if you are doing some sort of validation or verification, it is not with a visual examination of the material.
You don't know whether or not an abortion clinic does this procedure, correct? This procedure is from your practice? Or I'm sorry, this procedure is from talking to OBGYNs?
My knowledge of this is based on a number of sources.
Can you tell me some of those sources, please?
It is based on talking to OBGYNs, talking to patients, review of the literature, medical school, and personal knowledge.
So am I correct then to understand that you are testifying that in all cases to determine whether all the products of conception have passed, the patient must receive an ultrasound?
No, that's not at all what I'm saying.
Okay.
I'm saying I am not familiar with any circumstance in which we are asking a woman to examine the materials that she has passed to ensure that all of the products of conception have passed, because that would not be a reliable way of doing it.
Agreed. Do you know whether or not a patient is ever asked to bring in the products of conception so that the doctor can then determine whether all the products of conception have passed?
When a patient is asked to bring in the products of conception, it is not to make sure all of the products of conception have passed. It would be to conduct, for example, genetic testing. You could not ask an individual who is passing blood and clots at home to capture all of those blood and clots. Some of those would be lost in the toilet, for example. And so that would not be a valid way of making sure that all the products of conception are passed. If you needed some sort of way to make sure that everything had passed, ultrasound or beta HCG would be a much more reliable way of doing so.
So the comparisons of fetal size with seeds and fruit are helpful because a patient is more likely to understand the size of seeds and fruit rather than fetal tissue, right?
It's possible.
Okay. And comparing the fetus to fruits and vegetables is helpful because people know that a particular type of fruit, for example, an apple, has a size range, right? So a patient would understand that her fetus is within a size range, right?
Potentially.
And then isn't it common in pregnancy literature to speak about the size of a fetus in terms of such items? I mean, pregnancy literature generally, not necessarily medical literature, but pregnancy literature.
I am not aware of a medical provider who routinely uses fruits to help patients understand the size of their fetus.
Okay, I'm just talking about instances where there's books for pregnant women to read. Don't they typically explain at this time? Or have you seen any of the?
I have seen books that refer to fetuses by comparing them to fruit. Yes.
Yeah, and these books are intended for pregnant women, right?
Yes.
Okay. And these fruits and vegetables are very common in grocery stores, right? You could pick them up at Aldi, right?
Yes.
And isn't it true that you testified that the DHHS website information is factual?
Yes.
All right. And the DHHS fetal development material is correct information?
It is medically accurate. Yes.
Yes. Okay. And you don't think there's anything, well, I'll just move on because you answered that question. Oh, no, this is a different question. You don't think there's anything medically inaccurate in the descriptions of the abortion procedures, right?
They could be irrelevant, but not inaccurate. Yes.
Okay. And you agree that to the extent that anything in the materials is medically inaccurate, the law allows the department to correct the materials.
Correct.
All right. And all the DHHS materials are relevant to pregnancy generally, aren't they? I don't mean to be, I want to be very clear about this question. It's not a trick question, but I just mean because abortion, right, is a medical treatment for a pregnancy that's unwanted, correct? So it's generally involved with pregnancy, right?
I'm not sure what you're getting at. I think perhaps, yes.
Okay, you would agree, though, that all the DHHS materials are relevant to a woman's reproductive health, right? Generally speaking, that's the subject matter.
No,
No?
I don't think that infant care is necessarily relevant to reproductive care.
I believe you testified on direct, though, that reproductive care has to take into account a woman's social circumstances later on in life because it affects things like what kind of jobs they can have, what their opportunities are. And so it was considered within the purview of reproductive health for you to consider those consequences. Isn't that what you testified?
Again, there are impacts to your healthcare that can be wide ranging. It doesn't necessarily mean that those impacts are part of that health decision.
Okay. So then just because we've kind of muddied the waters, I'll just ask this question one more time then, and then we'll go with the answer you give me. So all the DHHS materials are relevant to pregnancy generally. Is that true?
They are relevant to pregnancy and childbirth and raising a child, that's a separate thing than pregnancy.
Okay. So would you agree, though, that the materials are, and this is a different question, relevant to prenatal care and childbirth?
No, because again, some of them are related to caring for a child, which is something slightly separate.
Okay.
So if, for example, you are going through a pregnancy and then giving that child up for adoption, you don't necessarily need to know about safe sleep practices. Two separate things. Pregnancy, raising a child.
Understood. You believe that the fetal development chart would be inaccurate to someone who knew from an ultrasound that her baby did not match the prediction or the description or a depiction because of a fetal abnormality. Isn't that right?
Yes.
Okay. But can't this charge of inaccuracy, can it be leveled at all general patient education material? Because they simply can't take into account every abnormality. Isn't that right?
If it is not relevant or if it is inaccurate for a patient, the healthcare provider should be able to not provide this information. There can be better ways to provide tailored information than this in those types of cases.
But educational material can't take into account every single abnormality, can it?
That's correct. And that's why it shouldn't be mandated.
So in those instances where someone has a rare fetal abnormality, then there's no patient educational material for them?
There is patient educational material for them, but the physician is mandated to provide this information.
Yeah. Isn't it a situation, though, where the physician could say, here's some some information on normal fetal development. Now, let me please explain to you how your case is different. Isn't that a proper use for patient educational material?
So if, for example, you have someone who is devastated because they have a non-viable pregnancy, a pregnancy where the fetus has anencephaly, for example, the brain has not developed. How is it helpful or relevant to show them a picture of a fetus with a normally developing brain and head? It is the only purpose I could see would be to cause distress.
Can you answer my question, please, doctor?
Sure.
Yeah. So my question is then, isn't it a proper use of patient education material to show it to someone in that circumstance and say, very delicately, this is what it normally looks like. Let me explain to you how yours is different.
No.
Okay. Are doctors trained on bedside manner?
Yes.
Okay. Aren't they trained to be able to give information in a sensitive manner?
They're also trained to withhold information that is not helpful. And in a case where information is not helpful, the correct thing to do would be not to provide that information.
So am I correct to understand then that doctors should never provide accurate medical information that's accurate, textbook accurate, in a sensitive manner even, because it may upset the patient?
What I am saying is they should not provide information that is factually accurate to other patients, but not to their patient, and that would serve no purpose other than to cause harm. If it would be helpful, sure, provide it. If the only purpose it is serving is to cause distress and harm, no, they should withhold that information.
How would the doctor know that it's well, let me ask this more directly. The doctor would have to then conclude that the only purpose of this information that he's withholding is that it causes harm, correct?
The doctor would have to conclude that this is not helpful or needed to the patient, or that it would cause harm.
Okay. So in such an instance, should the doctor then not explain the genetic abnormality with patient education material?
The doctor should find a way to explain it with material that is least distressing and most appropriate. And that is standard of care.
And if a doctor could believe that she is sufficiently trained to sensitively provide that information, correct?
A doctor should use whatever he or she believes is most appropriate in that situation.
A doctor could decide, though, that they have sufficient bedside manner to use this material
Sure,
to explain it to a patient.
sure.
Right. You provided input in creating the fetal development chart, correct?
I did not provide input in creating it. I provided some input when it was updated.
Okay. And you made sure that it was accurate when it was updated, correct?
I provided input as requested.
Isn't it true that the challenge law doesn't specify what the prenatal and parenting handbook contains?
I would have to read the exact verbiage to sort of see what the parameters are around that.
So it's correct then that you do not understand whether or not the content of the prenatal handbook is mandated by the challenge law. Is that correct?
I can confirm that the exact material and verbiage in that document is not mandated, but I would need to study it again to refresh my memory to see exactly what is mandated. However, I will say that the fact that it is called a hold on one second. The fact that it's called infant health education packet assumes that there must be materials after delivery, that there must be materials on parenting.
Isn't it true that the prenatal care and parenting pamphlet is not a burden to women who might want to continue their pregnancy?
No. I think it could be a burden for women who are considering adoption as well.
Okay. Well, then it's true then that the prenatal care, well, the prenatal portion would be relevant to that individual seeking or considering adoption, right?
Correct, but it's
Okay.
coupled with all of the safe sleep, breastfeeding.
Okay. So isn't it true then that the prenatal care and parenting pamphlet is not a burden to a woman who may want to keep the fully developed and term fetus?
Sure.
Okay. And therefore, for a woman who's trying to decide between abortion and parenting, it's a completely relevant pamphlet, correct?
Yes.
Okay. And you agree that feelings of sadness, guilt, anger, having trouble sleeping, or doing daily activities after an abortion are possible symptoms from abortion, correct?
Yes.
Okay. And the material doesn't state that the patient will develop a mental health diagnosis, right?
Correct.
Okay. It just says that they may have these feelings, correct?
Correct.
And the feelings are rare, correct?
I'll refresh my memory on that.
Yeah.
Correct.
Okay. Um, so you have testified before that the informed consent procedures that that use the department's materials may have caused additional obstacles for women. They may have caused emotional distress, and they may have provided women with information that was not applicable or medically accurate for their circumstances. But you don't know if they actually have done so for any particular patient, do you?
I do.
Please elaborate.
I have spoken to patients who have told me that these materials have caused them distress.
How many?
A handful. And I myself have experienced distress from these materials.
I'm not going to go further into that unless you would like to testify about that.
It's up to you.
All right. So when you say a handful, do you mean 5?
I would say more than 5.
Would you say less than 10?
Less than 10 women I've spoken with directly.
Okay.
But again, I also speak with physicians, other healthcare providers, abortion providers around the state.
Have you spoken to anyone who is ambivalent about the material?
No,
No. But if they're ambivalent, they might not have brought it up.
it's true.
And you don't think the material itself is biased on its own, like the words of the document are not biased, right? I understand your testimony regarding giving it to certain people in certain circumstances may make it biased in your opinion, but the words themselves are not biased, right?
Correct.
And isn't it true that you think the material becomes coercive because it may cause a patient to rethink her decision to have an abortion?
Yes, and it may make them feel guilty even in situations where terminating a pregnancy is their only option in the case of a non-viable pregnancy.
Right. The point of informed consent is not to hide accurate, relevant information, to ensure that the patient gets exactly what the patient wants when they first walk in the door, right?
Could you restate that? There was a.
So yes, I can. So it would be improper to hide or not disclose relevant information in informed consent just to make sure that the patient makes the same choice they were going to make when they first walked in the door, right?
Correct.
In fact, the point of informed consent is to provide a patient with all the information relevant to her decision, correct?
Correct.
And isn't it true that the challenge laws have been in effect for several years?
Correct.
Right. And the informed consent obtained by Northland during this time has been completely valid, right?
I can't speak about the practices of any one individual clinic where I have not worked.
Okay. Do you believe that the informed consent obtained by abortion providers while these laws have been in effect is invalid?
No, but I think that the informed consent could have been done in a more nuanced, more tailored, more empathetic way that did not cause as many obstacles. So I think we have found workarounds to these laws.
But the informed consent obtained using these laws was valid.
Yes,
Okay. And it's true that the standard of care for informed consent has not been changed by the Prop 3 constitutional amendment, right?
Prop 3 has not changed the informed consent process, but we have to understand that as medicine changes, we continue to accrue data. Medical practice and standard of care can change, which can impact informed consent. Yes.
Yeah. But Prop 3 is not an
No.
informed consent law.
No.
Okay. And you agree that an informed consent procedure performed consistent with the standard of care is not a burden, right?
Say that one more time.
An informed consent procedure, or if you have an informed consent process and it's performed consistent with the standard of care, then that informed consent process is not a burden, right?
Objection, calls for legal conclusion, and it's vague.
I'm sorry, to be clear, I don't mean a legal burden, I mean a burden on the patient.
One more time.
So a properly, an adequate informed consent procedure that was done consistent with the standard of care, that informed consent procedure is not a burden on the patient, right?
It should not be correct.
But it would not be because it's consistent with the standard of care, right?
Okay.
I'm sorry, is that a yes or a no?
It's very hard to answer in such generalities.
I'll ask another way.
Okay.
Is it possible to, is it possible for the standard of care, for anything that's done according to the standard of care, to be a burden on a patient?
Yes.
Okay, so with that, then can you give me an example?
So what I will say is yes, but the goal is to minimize the burden on the patient whenever you can. So sometimes it is difficult to talk about difficult topics. Sometimes it's difficult to talk about death and dying. Sometimes it's difficult to talk about complications. Some of these can be burdens on the patient. The goal of this doctor-patient relationship is to minimize the burden on the patient, is to minimize the harm that is caused. And that's all we can hope to do.
Okay, so the standard of care will never eliminate all the burdens on the patient.
Yes.
Okay, so there's always going to be burdens no matter what we do.
Not in every case. The goal is to minimize burdens as much as we can.
Okay, but the standard of care is not that all burdens be eliminated, correct?
They are to eliminate as many as we can.
But to be clear, of my question is, the standard of care does not require that all burdens be. The standard of care does not require that all burdens be eliminated. Is that correct?
Objection. Asked and answered.
Answer one more time and then we can move on.
The goal of these physician-patient interactions is to minimize the burdens on the patient, to make things as comfortable for the patient as possible.
Informed consent is a patient right that protects the patient, correct?
Correct.
Are protections burdens?
I guess it's possible, yes.
So you've said that the 24-hour waiting period is discriminatory because we don't mandate 24-hour waiting periods for other procedures like a vasectomy, correct?
There is no state mandated 24-hour waiting period for all vasectomies. That is correct.
Isn't it true, though, that there is a Medicaid rule in Michigan that requires a 30-day waiting period between informed consent for sterilization and the procedure?
That is a Medicaid rule, which is a health insurer. So health insurers can have whatever rules they would like. It is a federal rule, and it is not a state legislated mandate.
I'm sorry, are you aware that it's an administrative rule promulgated by the state of Michigan?
It is a federal rule that is promulgated by the state of Michigan because the state of Michigan administers Medicaid, which is insurance.
Okay, so this insurance is allowed to impose waiting periods?
Insurance can promulgate whatever rules they would like.
Okay, so Prop 3 doesn't affect, well, I won't add, that'll draw an objection on a legal conclusion, but it's okay in your opinion for an insurance company to tell people that they have to wait 30 days. Is that right?
Insurance companies have all kinds of rules. There are rules about when MRIs are approved. There are rules about when CT scans can be approved. Insurance companies can have whatever rules they would like.
Okay, but the state here is doing it, right? It's not the insurance company because
It is a
Medicaid.
federal rule
Yes.
that applies to Medicaid. And because Medicaid is administered by the state, it applies to state Medicaid.
It's nonetheless a rule, though, that applies to men seeking vasectomies if they're covered under Medicaid.
By that insurance, yes, it is an insurance rule, which is
Yeah.
very different to me than a state legislated universal mandate.
So, but those individuals have to wait 30 days to get a vasectomy, correct?
Yes,
And a vasectomy is reproductive health covered under the Reproductive Freedom Act, correct?
but again, we're talking about an insurance rule.
Okay, but my statement's true,
Yeah.
right? Okay. You've testified that a 24-hour waiting period may turn into 2 weeks and may actually increase the riskiness of a procedure or that type of procedure a woman is eligible for, right?
Yes.
Okay, can you go to Exhibit K7 in the bigger binder? Actually, I believe it's K7. Is it in here? Yeah. And it's page 1. Do you see down at the bottom half of the page, there are paragraphs that a patient is expected to initial?
I do.
And do you see the 4th one where it states, I understand that the type of ultrasound performed at the facility is done to determine length of pregnancy only, and that the ultrasound may range plus or minus 2 weeks. Do you see that?
I do.
Counselor, can you just direct me where you are? I think I looked at the wrong exhibit.
Yeah, yes, Your Honor. I'm on Exhibit K7 and I think-
K7, okay, thank you.
Yeah.
Please continue, sorry about
Okay.
that.
So that statement that I just read for you, where it spoke about the ultrasound ranging from plus or minus 2 weeks, that 2-week delay is within them that you spoke about, where the 24-hour period can extend to 2 weeks even. That's within the margin of error of Northland's ultrasound procedure, correct?
Yes, but you're not just relying on ultrasound. You're also relying on last menstrual period. And so using those two pieces of information together is what gives you a better estimate of gestational age.
Do you think that that Northland's use of ultrasound is problematic? Do you think that would be, let me put it this way, since I assume you don't have knowledge of Northland's procedures, correct?
Correct.
Do you see this, the next sentence after what I've just read you, where it says, I understand the ultrasound today will not diagnose any other conditions such as maternal or fetal abnormalities, ectopic pregnancy, pregnancy outside the uterus, sex of the fetus, a very early pregnancy, et cetera. Do you see that?
I do.
So at least if this is true, if this is what Northland uses their ultrasounds for, then isn't it true that they're in the same boat as, say, the so-called crisis pregnancy centers?
No.
Why
May I
is that?
clarify? Again, I don't have any direct knowledge of Northland Family Planning or their practices. This to me looks like a legal liability statement. So what people are writing for legal liability is to cover them from a malpractice suit. If, for example, there is, in addition to an intrauterine pregnancy, there is also an ectopic pregnancy, which can happen. So this to me looks like a legal statement. And I would assume that there is someone on staff who is medically trained to interpret the ultrasound.
So it's your understanding that abortion clinics have someone on staff to diagnose conditions such as maternal or fetal abnormalities?
I would assume that there is someone there who can read and verify the results of the ultrasound. This appears to be a legal statement because sometimes at very early stages of pregnancy, it's too early to tell.
I understand, doctor. I just want to be very clear. I'm just asking, am I correct to understand that your understanding of abortion provider practice, including clinics, standalone clinics, is that they diagnose maternal and fetal problems?
My understanding is that they likely do not have an MFM, maternal fetal medicine specialist on staff, that they don't have someone who specializes in those things. But my understanding would be that they have, at the very minimum, an OBGYN on staff who could diagnose a major problem.
Isn't it true that you have no data on how often Michigan's 24-hour waiting period has caused a patient to forego an abortion procedure they otherwise would have wanted?
I do not
Have the data.
have the data.
Yeah. So, please look at Exhibit 1. I believe it's in the smaller binder. Have you reviewed, this is the challenge law, correct?
Correct.
And you've reviewed this?
I have.
Okay. And down on subsection 3 at the near the bottom half of the page, can you see where that is? It says it starts with parenthetical 3 and then subject to subsection 10. It's on the first page.
Yeah. Yeah.
It's really difficult to read. I apologize. But do you see it?
I think so. Yeah.
Okay. And it states a physician or qualified person assisting the physician shall do all of the following not less than 24 hours before the physician performs an abortion upon a patient who is pregnant. And then there are some items there, A, B, and then B has 3 items underneath it. Do you see that?
I do.
And would you like me to read those, or if I ask you a question about them, will you be able to tell me if it's your understanding?
I think you can go ahead and ask me a
Okay.
question.
So those sections require, isn't it true that those sections require the abortion provider to confirm that the patient is pregnant and determine the gestational age of the fetus?
Correct.
And they also require that the abortion provider orally describe to the patient the fetus's probable gestational age, who to contact in case of complications, and how to obtain pregnancy prevention from the department.
Yes.
Okay. And then there's a subsection C underneath that, right? And that speaks about all that written standard summary stuff
Mhm.
that you've been speaking of today, right?
Mhm, mhm.
And that stuff can be obtained from the website, right?
Correct.
Okay, so my question is about subsection 3A and B and the parts under that. Those things only. Right? And isn't it true that a doctor can confirm a patient is pregnant and determine the probable gestation age of a fetus over the phone?
Medically, yes.
Okay, and a doctor can also provide over the phone the oral descriptions of gestational age, who to contact in case of complications, and how to obtain pregnancy prevention resources, right?
Sure.
All right, and then we talked about the rest of it. Subsection C can be done on the website, right?
Yes.
And so if that can all be done on there, isn't it true that 2 trips are not necessary?
So as a physician reading this statute, if I am reading confirm according to the best judgment of a physician, the patient is pregnant and determine the probable gestational age of the fetus, it really requires me to think about the medical risk I am undertaking if I endeavor to do this over the phone.
Are you aware whether or not medication abortion is provided via telemedicine in Michigan?
It is.
Okay. Is it problematic then for them to provide that service via telemedicine?
I'm sure it took a lot of looking at this statute and how much risk they felt confirming pregnancy without a visit. And I would assume that different physicians interpret this differently.
Okay, understood. But in your understanding, the individuals, the medical providers providing medication abortion via telemedicine are not violating the law. Is that correct?
Correct.
So isn't it true that APC's scope of practice is determined by the licensing body, by the institution, and by the physician with whom the physician assistant works with?
Correct.
Okay, and before an APC can perform an abortion, the procedure has to be within the APC scope of practice, correct?
Yes.
Okay, and for a procedure to be included in the APC scope of practice, the APC has to be trained on the procedure.
Correct.
Okay, and the APCs would also need to know how to deal with some immediate complications.
Correct.
I mean, and by that, I don't mean more than just recognize, but there are immediate complications they must be trained to deal with.
Yes.
Okay. But they should also be able to recognize other complications so that they can get urgent help.
Correct.
Right. And the health code and administrative regulations limit APC scope of practice, correct?
Correct.
Right. And so isn't it true that if the challenge laws were repealed, APCs would not immediately perform abortions because they would need to be promulgated administrative rules and APCs would have to receive additional training?
My understanding is that there are already some APCs who would be qualified at the very least to provide medication abortion.
So I'd like to talk about which professions are included in the term APC. Is it your understanding that midwives, and I do not mean certified nurse midwives, but I mean midwives generally, are considered APCs?
I would consider certified nurse midwives APCs. I'm not sure about the other designation, and I would have to say this is not my area of expertise.
Okay. But generally speaking, regular midwives, and I don't mean to denigrate their profession in any way, are significantly more limited in what they can do than, say, a certified nurse midwife.
That is my understanding, but this whole area is not really my area of expertise.
Okay. But there is a distinction between the two.
In my understanding.
And so when you gave your testimony regarding APCs, did you mean to include regular standard midwives?
I think I would need to consider that. And what part of my testimony exactly? This is not really This whole area is not my area of expertise. So I think either if you have a question about something I've already testified to, I'd love to understand what that was, or perhaps we should avoid this whole area.
Oh, we can avoid it.
Okay,
Unless something comes up later.
okay.
Okay. So, and even if the challenge laws were struck, a medical board could still decide that abortion should not be included in the scope of practice for a particular APC, right?
Tell me what you mean by a medical board.
I retract my question. That's a very good point. I just read it right up to, I apologize. I'll ask this. Just, do you know whether or not APCs have to be supervised by a physician?
Some, not all.
Okay. In your, you've testified that abortion providers already administer abortion screening as a matter of course, right?
One more time.
So you've testified that abortion providers already administer abortion screening as a matter of course.
What do you mean by abortion screening?
So that's the actual gist of my question, because I believe also you've testified that abortion screening is generally performed.
Okay, coercion screening.
Oh,
You
was
said
that?
you said abortion screening.
Did I? Oh, I'm
That's okay.
sorry.
So-
Thank you very much.
Yeah.
Yeah. So do you believe that abortion providers already provide this? I did type it that way, coercion screening as a matter of course?
I believe that, yes.
Okay, but didn't you also testify though that it's medical providers, they screen for it if they felt there was an opportunity for coercion to be a factor?
You would screen for it in a way that was appropriate. Based on the circumstances.
So it's possible then that an abortion provider or a medical practitioner will say, would see a situation and without asking any other questions or probing any more deeply, would conclude no coercion going on here.
No, what I mean is there is a whole context around this. If your patient comes to you and starts with, my partner and I have discussed, my partner is very supportive, my partner and I agree, nobody is coercing me, I believe we are making this decision together, we feel really good about this decision, you would not need to say, is anyone coercing you? Because those issues have already been addressed by the context. So what I mean is you would have to screen based on what has already been provided by your patient, what has already taken place in the conversation. And in fact, what is awkward is when you are reading from a script or providing something standardized when those questions have already been answered in a very natural way in your conversation.
Isn't it true though that the department's abortion coercion screening tool doesn't mandate that the questions be asked in any particular way, or that they're even asked at all? They are suggested questions, correct?
Let me refresh my memory.
Are you looking at Exhibit 6? No,
I am looking at
Exhibit 7.
6.
Exhibit 7, I believe.
It does allow for open-ended questions. These do appear to be suggested questions.
Isn't it?
However, I think that abortion providers have to provide this pre-screening summary to patients. which again, may or may not be necessary or needed.
But it's true that the only mandated coercion procedures are that the provider actually perform the screening, record that they perform it, and record any disclosures and referrals, right? That's the only thing absolutely mandated.
Your Honor, objection. Counsel is actually misreading the statute.
I'm just asking of her
I
understanding
want
of,
the record to be clear that if he is talking about the law, we need to have a correct summary of the law in the record. I repeat. And yes, we should all be looking at the law that we're discussing.
Your Honor, she's testified at length about the coercion screening, about how she believes it's coercive, how it's mandated. She's spoken at length about the actual screening tool, Exhibit 7 that the department produces. She clearly has an expert opinion on what's mandated in it. And I'm asking her what that
Can you
is.
point her to the part of the statute that you're also referring to?
It's Exhibit 2, Your Honor.
Thank you. But to be clear, Your Honor, I wasn't asking about the statute.
I understood
But-
those questions to be about the statute while looking at Exhibit 7.
All right.
I don't have an exhibit 2. Mine goes from exhibit 1 to
Oh, we
exhibit
don't,
4.
we have a larger folder. Yeah, thank you.
Could you refer me to the? It's just tab 2 in here, just that one.
Yeah,
Okay.
it's just a short statute. I believe what counsel would like to get on the record is that the statute says shall orally screen the patient for a coercion report using the screening tools developed by the department. I believe that's what she's getting at. I acknowledge that that's there. Right, but that aside, the requirements are that they perform the screening according to or using the tools, and that they record that they performed it, and that they record any disclosures and referrals, right?
Your Honor, the mistake continues to be perpetuated that you're summarizing, you do have to say that the screening has to be oral.
Your Honor, I would just like to finish my questions. These kind of things can be cleaned up on direct, or redirect rather. They don't need to be cleaned up now.
Your Honor, you can't
I-
mislead the witness. I'm very happy to clean up counsel's misperceptions on direct, but you cannot mislead the witness.
Mr. Tuttle, I don't think Mr. Tuttle is misleading the witness, but if you see that it's going outside of what the statute says, make your objection, and I'm sure he can reframe the question so that it's within the confines of what the statute is, as well as the screening tools that Dr. Bakarian is testifying about.
Your Honor.
Is that acceptable, Mr. Tuttle?
I'm fine, Your Honor. And hopefully I am very near the end of my outline. So I refer you to page 4 of Exhibit 7. And do you see down there where the tool states that state law requires documentation of the patient's record, that the screening for coercion to abort was done, and the findings of that screening documentation must include any referrals made in response to disclosures of coercion to abort?
Yes,
Okay, so you agree those are mandated, correct?
correct.
Okay, and then it's your understanding that the rest of this tool mandates it. In other words, they're mandated to create a safe environment for asking screening questions. Is that your understanding?
Yes,
Is that a burden?
nope,
Okay, they're mandated to normalize the screening process. Is that a burden?
nope,
All right, and they're mandated to ask screening questions. Is that a burden?
Only if, as I mentioned, these questions have already been addressed through prior conversation.
Okay, so it is your understanding, though, that the department can modify this tool, correct?
Correct,
And the law does not mandate what this tool contains, right?
correct.
And so the department can fix the problem you've just stated, that sometimes you shouldn't even ask a question if it's not necessary, right?
Correct.
All right. Is it your understanding that the law required the department to make this?
That is my
tool?
understanding.
Yeah, to make a tool, right?
That is my understanding.
And that because, and I believe the whole issue of orally screened. Do you understand orally screened to mean you have to ask the question, are you being coerced?
That is how it sounds to me.
Okay, so that's why you think it's problematic.
Again, I just think it is a mandate when there is no need for a mandate.
Okay. I will move on. It's your understanding that if abortion patient's a minor and it's determined that there was coercion to abort, that disclosure has to be reported to CPS, correct?
Of course.
Okay. And all healthcare providers are mandatory reporters
Yes,
of child abuse.
yes.
Is it possible that someone could be missed? In other words, a patient who's being coerced to abort could be missed if some APC somewhere developed their own screening questions?
There's always the possibility.
Wouldn't it be helpful for the Department of Health and Human Services that oversees child protective services? Wouldn't it be helpful for that department to develop best practices for screening for coercion?
It could be helpful.
Yeah. Isn't DHHS actually the best agency to develop the best practices?
Not necessarily, and I will explain why. Most of what we do in public health is provide information to the public. Very little of what we do, a minority of what we do, is provide information to healthcare providers. We rely on healthcare providers to seek their knowledge, training, best practices from their practicing bodies, organizations of which they are members, their licensing bodies. So educating healthcare providers is a very small portion of what MDHHS does. We typically advise patients and the general public. We advise the general public. So for example, you may see, if you ever happen to use a female restroom, you may see a poster in there talking about, here's a number you can call if someone is abusing or threatening or coercing you. Most of what we do is direct outreach to the public, not training healthcare providers.
That raises a question I'd like to ask. That pamphlet, that notice in the bathroom, do you believe that's a burden on patients?
No, because no one is mandating that they read it, signing that they read it. It's just there.
Okay, so if it's a notice, it's fine.
A non-problematic notice is fine.
Okay. But back to my earlier question, though, I'm more concerned with the notion of child abuse and the child protective services. Is there a better agency to help healthcare providers deal with cases, the law surrounding child abuse?
I don't know if there is a better agency, but MDHHS is an agency that can help with that.
Do you believe that the department failed to provide best practices with these abortion screening tools?
As we've defined best practices here today, we have talked about best practices, meaning taking medical guidance, medical knowledge, training, research, and combining it with a tailored approach to your patient. So I don't know if anything DHHS provides can be standard of care. We're relying on the healthcare provider to achieve standard of care.
So you're not an OBGYN, correct?
I'm not.
And you have not completed a surgery residency?
I have not.
Okay, so you're not a surgeon,
I'm not a surgeon.
all right? And your certifications are in internal medicine, correct?
And infectious diseases,
And
yes.
infectious diseases. Is infectious diseases separate from internal medicine?
Yes.
Okay. And isn't it true that all your peer-reviewed publications concern infectious diseases?
Ooh, no,
Okay. Do you have some that don't?
I do.
Which one?
There is one that is a psychiatric publication. And then since then, yes, they have all been infectious diseases.
Okay. The psychiatric publication, is it in your resume?
I might have removed it because it's old.
Okay. Do you know about when you produced it or drafted it, authored it?
In college.
Okay. And you have not received any training specific to abortion, correct?
Correct.
And you yourself have not performed an abortion, correct?
I have not independently performed an abortion.
Yeah, I do remember you stating that you assisted in a DNC procedure in medical school.
I have assisted in some DNC procedures in medical school.
Okay.
Yes.
Do you recall whether they were, I remember you stating you could not recall whether they were for a miscarriage management or an abortion.
Correct.
Okay. Do you know now?
No.
Okay. And you have no knowledge of how Northland practices medicine, correct?
Correct.
And you don't know how thorough their history taking is, their patient history taking?
Correct.
Okay. And you can't speculate on the protocols used by every abortion provider in the state, right?
Correct.
And you don't know what educational materials or consent forms they use, right?
Correct.
And your knowledge of how abortion is practiced, is it based on when you volunteered at a Planned Parenthood clinic in high school?
No,
Okay.
not just that.
Okay. Is it with your conversations with OBGYNs and others?
Many conversations with OBGYNs and patients.
Okay. But your knowledge of how patients make abortion decisions is primarily from hearsay?
No, I have cared for many young women with unplanned pregnancies.
Okay. Who then had abortions?
Some of them who then had abortions.
Okay. And you don't know whether Northland or any other clinic will accept a screenshot of a DHHH website confirmation page, right?
I do not know.
Okay. Most abortions are elective procedures though, right?
Yes.
And your opinion of the crisis pregnancy centers that are in the material that you testified about, that's based on an issue brief from ACOG, right?
Not just that issue brief from ACOG, it's also from conversations with abortion providers, OBGYNs, and patients around the state.
I just need to be able to pronounce it for the record. It's the American College of Obstetricians and Gynecologists, correct?
That is one source of this information, correct?
Yeah, and it's an issue brief, right? It's not an evidence-based paper.
What was included was an issue brief in the reference materials, correct?
Yeah, I mean, in other words, it's not evidence-based.
No, but I'm sure I could find you some evidence-based material if you'd like.
And You did testify, though, in your deposition that the colleagues that you spoke to about the crisis pregnancy centers, from whom you learned about the crisis pregnancy centers, you testified that they don't work at any of the centers.
Correct, because they don't employ physicians.
None of them do?
As far as I know,
It's your, okay, to be clear, your understanding is that these crisis pregnancy centers do not employ licensed medical professionals. Is that right?
my understanding is that most of them do not hire physicians.
Okay, so they may have licensed medical professionals, but most of them, you believe, do not have a physician.
That is correct.
So would it be proper to say then that if one of these organizations had a licensed physician on staff, you would not consider it a crisis pregnancy center?
No, I think that if it was an outfit that was designed to steer women away from abortion and provide information in a biased way, I would still consider it a crisis pregnancy center.
You're the chair of Michigan's opioid task force, right?
I am.
And you're aware that Michigan had a health crisis caused by doctors liberally prescribing opioids to patients who didn't understand the risks, right?
Who didn't understand the
The
risk?
patients.
Yeah. And the physicians in those early days also, many of them did not understand the risks.
Yeah. And so Michigan addressed this crisis in part by requiring a form developed by DHHS called the opioid start talking form, right?
Yes.
And in fact, just to get you your opinion on it, or rather your verification of it, can you look at Exhibit 11, or sorry, L? It's been a long day. I'm
Me too, man.
sure you're feeling it as well. Is Exhibit L that form?
It is.
Right. And it's a standardized form that has to be signed by the patient, acknowledging that the patient has received certain information from a doctor, correct?
Yes.
And some of that information may not be relevant. I understand the patient may not actually receive the information, but this form has a bunch of items on it that may not be applicable, right, to everyone.
Yes.
Like I'm thinking of if a male was receiving this form, he certainly is not a female who is pregnant or of reproductive age.
May I just ask about this?
Yeah.
I really would need to see how old this form is. And this is not typically how things are done anymore in the era of electronic medical records. My perception is that this is quite old.
Do you see the revision number down at the bottom? Are you familiar with the state of Michigan's revision numbers?
Yes.
And it appears to me to be a March 2020 revision number. Would you agree with me on that?
Yes.
Okay. Your Honor, may I have 5 minutes? And then I should be able to wrap up with just a few questions.
We'll take a short 5-minute recess.
Okay, thank you, Your Honor.
Are we not allowed to talk?
Now in session.
Okay, welcome back. Dr. Bagdasarian, you are still under oath. Mr. Tuttle?
No further questions, Your Honor.
Okay, thank you very much. I am assuming that we have questions from the other defendants. Mr. Ping, do you have you guys worked out what order you're going to be asking questions? And I'm actually going to defer to Dr. Bagdasarian since you have been on the stand for 4.5 hours now. Would you like to continue questioning or would you like to break for lunch for a little bit?
I'm good to continue if that's okay with
Is
everyone.
that amenable to the plaintiffs? Okay, then. Mr. Ping. Mr. Braverman?
For the record, I will have just a few questions as well.
Okay, we will just continue with the examination then.
All right. Good afternoon, doctor.
Good afternoon.
Thank you very much for your time.
Mr. Ping, if I could also have you just place your appearance on the record.
Sure. Daniel Ping, appearing on behalf of Director Hertel. Now, doctor, recently you worked at the Corner Health Center, correct?
Yes.
Can you tell us a little bit about that?
The Corner Health Center is a health clinic in Ypsilanti that provides health care for young people under the age of 26 from underserved communities. And these tend to be patients who are uninsured or underinsured.
All right. And what types of care did the clinic or the Corner Health Center provide?
We essentially provided all kinds of general medical care to young people. Myself in particular, I provided care to patients generally between the ages of 18 and 26. Many of them were female. Several of them were coming in with reproductive health care needs, including pregnancy, STIs. Many of them were already young mothers and were dealing with, in addition to diagnoses of pregnancies, many of them were also dealing with transportation issues, housing insecurity, substance use disorder, mental health issues, among other things.
All right. While working there, did you experience any of your patients having difficulty making or keeping appointments?
Many. It was very common. We had a very high no-show rate when it rained or when it snowed because many of our patients relied on public transportation and it was simply too hard to take the bus or find a ride, especially in bad weather with other young kids in tow. And many of my patients would show up with 1 or 2 toddlers with them as well.
All right. Now, did the center provide abortions?
We did not.
Is there any reason to believe that these same obstacles would not face individuals seeking abortion care?
They definitely were also impeding patients' access to reproductive care, like abortions. I took care of many patients who we were diagnosing with early pregnancy and who we would refer out to places like Planned Parenthood. And their first question would usually be, how do I get there?
Okay. Thank you. Now, we talked briefly about crisis pregnancy centers that the department is obligated to list contact information for on its website. Now, you testified that this is concerning because these are unvetted environments, right?
Correct.
That's true because they might be coercive?
Correct.
And is it also true because it might be medically dangerous?
Yes.
Based on are you aware of any licensing or staffing requirements imposed on these facilities?
I'm not.
All right. So even if these facilities were staffed with individuals who were 100% unbiased, would it still be a potentially dangerous environment, medically speaking, for patients to get their ultrasound there?
Yes, if there was no one there to interpret the results of the ultrasound.
Thank you. Now, you, in a few different contexts, you've talked about patients who have a wanted pregnancy, but for whatever reason, terminating that pregnancy is the best, if not the only option. In some cases, these folks have had conversations with their physician already. And then, so the decision in these cases has more or less been made. Am I kind of reviewing
Correct.
this hypothetical correctly? Okay. Now, if that's the case, and then these individuals have to return to these mandated materials, why is that harmful? The decision has been made. There can't be any coercion, right?
In those cases, they may either make someone feel guilty about a decision that they've already made. They could cause emotional distress when they're reading about normal pregnancies. They could also make people question their decision-making, even when there is not another safe alternative. So in the case of a non-viable pregnancy, if that pregnancy is not terminated, or if an intervention is not made, there is sometimes the risk of that progressing to things like sepsis. And even in a case where there is not a good alternative for that woman, I think providing biased coercive materials could make them question the decision that has already been made.
I'm hopping around a lot, but that's just the nature of the thing. I want to turn your attention back to Intervenors Exhibit B. This was the AMA standard for informed consent, one of them. Do you have that in front of you?
I do.
Would you agree that this relates to medical interventions or treatments?
Yes.
Okay. Is the adoption process a medical intervention or treatment?
It is not.
All right. Is certain postpartum parenting info like attachment or cuddling, the value of cuddling, is that a medical intervention or treatment?
Not typically, no. Sorry.
All right, so is something, do you think that the AMA was getting at something like the adoption process when it suggests that relevant alternatives be discussed with the patient?
Likely not.
Now, I understand you're not a lawyer, and I think I recall your testimony on cross-examination with Mr. Tuttle to reflect that you weren't really sure whether the parenting information packet was required to be produced. Am I remembering that correctly?
No, my understanding is that it is required.
But required under a different law, perhaps. Will you just look at Plaintiff's Exhibit 1? That's the statute.
Okay.
I mean, here, maybe a more fundamental question. This packet is produced not to comply with these laws, but to be available to expectant parents, right?
Correct.
All right. So on the second page of the statute, I'm looking at little e, it's maybe 7 or 8 lines down. And that obligates the department to provide the patient with a physical copy of the prenatal care and parenting information pamphlet distributed by the department under section 9161.
Sorry, could you tell me where you are again?
I'm on the second page.
Yep.
little e in
Oh,
parentheses.
little e. Yes,
Okay. So under these laws, the department has to require the patient to view, or the physician does, not a tailored document, but something that is prepared for a completely different purpose for people who want to learn more about their wanted pregnancy or their expected pregnancy.
correct. And I'm so sorry, could I add something?
Certainly.
And I'm just taking a look at F as well. I think when Mr. Tuttle cross-examined me, he mentioned that the only thing that the physician had to do was do a coercion screening and document that it was done. But it does actually say here, provide the patient with a physical copy of the pre-screening summary on prevention of coercion.
Thank you for cleaning that up. Now, looking back to little e, the packet, DHHS has no discretion as you read the statute, right? You have to give over the packet that is prepared for expectant parents.
Correct.
So the only way to improve that packet for patients who are seeking an abortion would be to undercut the department's goals in crafting that for another group of people.
That's correct.
And that could potentially be a disservice to people who are expecting to be parents and looking to that document for information.
Absolutely. And what's interesting, I'm so sorry, I don't know if I'm allowed to, can I interject?
Please do.
What's interesting is we don't require that parenting packet goes to people who have given birth. There's no mandate to say you must give it to people who've given birth. Isn't that odd?
You're the witness. All right. Is it possible for informed consent to be invalid without the physician's knowledge? And let me know if that doesn't make sense. I'm envisioning a situation where the patient really just maybe wasn't paying attention or tried, but really did not understand and did not communicate that to the physician.
Yes.
Right. And I think earlier you said that not all informed consents that are obtained under these challenge laws are per se invalid.
Correct.
But some could have been.
Correct.
Right. Okay. And
Objection, Your Honor, that misstates testimony.
it's a little late.
I understand the answer has already been given. I just wanted to lodge the objection.
All right, and I'm just going to touch on coercion again real quickly. So, and I think we talked about this, but just for clarity, someone might seek an abortion because they are coerced to do so by a partner or someone else.
It's true.
And there are other forms of reproductive coercion, coercion to become or remain pregnant.
Very true.
Right. And there are other forms of healthcare coercion, right? Coercion not to get an STI test, for example.
Absolutely.
Right. And to your knowledge, DHHS is not required to create coercion screening materials for any of these procedures.
Yes, that's correct.
All right. And one more thing, which I might have said already, but it wasn't true. That pamphlet that you were asked about, I think it was Exhibit Q. Do you still have that?
Exhibit Q in this book.
I think it was the loose leaf packet, just the
Oh,
first and
okay.
second page.
Got it. Yes.
Doctor, have you provided end-of-life care?
I have provided end-of-life care in many, many circumstances.
Right. Have you ever issued this pamphlet to a patient?
I have not personally ever given this pamphlet to a patient.
That's all I have. Thank you, doctor.
Thank you.
Appearance, Christopher Braverman on behalf of Director Marlon Brown, Director of the Michigan Department of Licensing and Regulatory Affairs. Good afternoon, Dr. Bagdasarian.
Good afternoon.
As you may have heard, I represent Defendant Marlon Brown. He is the Director of the Michigan Department of Licensing and Regulatory Affairs. Are you familiar with that agency?
Yes, and I know Director Brown well.
Very good. Are you familiar with the acronym LARA?
Yes,
So if I use LARA as the acronym for the agency, you'll know what I'm referring to.
yes,
LARA. Makes things easier, certainly for all of us. You were asked during cross-examination about a standing order for dispensing opioid antagonists. Do you recall that?
yes,
Now, those questions were prefaced with a reference to LARA. Do you recall that?
yes,
And just to clarify, you issued that standing order based on your authority as the state's chief medical executive, right?
that is correct.
Did Laura have anything to do with the issuance of that order?
Not as far as I'm aware.
Okay. Very generally speaking, the purpose of that standing order was to allow Michigan licensed pharmacists to prescribe naloxone in a manner that was ordinarily not allowed under the law, correct?
That's correct.
Thank you. You were also asked during cross-examination if Michigan's physician-only rule did not exist, would there need to be specific rules issued by the other health profession boards that govern, for example, the APCs and their professions? Do you recall that?
I do.
Is it fair to say that sitting here right now, your answer to that question is that you don't know?
That is fair.
Now, you are currently licensed to practice medicine in Michigan
I am.
as an MD.
Yes,
When did you first get your license?
in 2005.
Have you maintained that license in active status since then?
I have.
Do you have a general understanding of how MDs are governed in Michigan with respect to LARA and the Michigan Board of Medicine, generally just in terms of licensing?
I do.
Do you also understand that the other health professions in Michigan are governed by their own profession-specific board?
Yes,
So your testimony is that you simply aren't sure how those individual boards would respond in a situation where Michigan's physician-only rule was not in effect.
that's correct.
So they may choose to issue rules or they may not to.
That's correct.
And specifically rules addressing what type of training or experience would be needed for those professions to perform abortion care.
That's correct.
Thank you so much. Nothing further.
Do you have any other defendants who would like to do an examination? Okay, then redirect.
Yes. 5 to 10 minutes and.
Yeah.
Sure, Dr. Baxter would like to get reasonable time. Hello again, doctor.
Hi.
Is there a difference between whether a doctor can provide information to patients and whether they must because of a state mandate?
Yes,
You were asked about doctors having their own biases.
yes,
Is there any reason to believe that doctors who provide abortion care have more or some special or financial bias that requires them to be uniquely regulated by the state compared to other doctors?
no,
And even if a doctor does have financial motivations or unethical motivations, are there already ways of addressing such unethical medical practice unrelated to the laws here?
yes,
What are those ways or some of those ways?
If someone is practicing medicine in an unethical way, there is LARA and licensing requirements. There are board certification that can be withdrawn or removed. There are institutional boards that review the practice of healthcare providers that they employ.
You were asked about how many abortion patients are receiving abortion care from a provider that they do not have a pre-existing patient-provider relationship with.
Yes.
Right? For patients who establish a new patient-provider relationship with their abortion provider, can they get information from that provider
Yes.
without the DHHS materials?
Yes.
Can the DHHS materials interfere with that new patient-provider relationship?
Yes.
I'd like to quickly ask you about Defendant's Exhibit B. So that'll be in the binder there, yes. So Mr. Tuttle read you part of Exhibit B, starting with in subpart B, right?
Yes.
The physician should include information about, right?
Yes. Mhm.
Could you please read me the sentence that comes before that sentence?
Present relevant information accurately and sensitively in keeping with the patient's preferences for receiving medical information.
Is that in line with the concern you mentioned to Mr. Tuttle that
Objection, Your Honor. I think a lot of these are leading. I understand that technically a leading question is not necessarily a yes or no question. It's one that implies the answer, but when you have a whole series of questions in this manner, I think we all know they're leading.
Your Honor, I don't think I've asked a single question where I knew what answer Dr. Bagdasarian was giving. So it was certainly not intended to elicit a specific answer.
Okay, I'm going to allow her to ask questions about this Exhibit B because I think it's very tailored towards what your cross exam was. Just be sure to reframe the question so that it's not leading and allow Dr. Bagdasarian to provide her testimony.
Is subsection B in the whole that we have now read it consistent or inconsistent with your testimony that options should be relevant?
It is consistent.
And same question for your testimony that options should be accurate.
Yes, consistent.
Doctor, in your understanding, if a patient wants an abortion, if a patient is seeking an abortion, do they or do they not want to be pregnant?
Typically, if they are seeking a
I recognize that, yeah, maybe there's some nuance there. If a patient is seeking an abortion for a reason other than their own, for a reason other than a pregnancy complication that threatens their health or a non-viable pregnancy, in your understanding, do they want to be pregnant?
they typically do not want to be pregnant.
Does that patient have the option of going back in time and not becoming pregnant?
No, they do not.
Doctor, you testified on direct and on cross to the issues you identify with Exhibit 4, the MDHHS packet, right? As Chief Medical Executive, do you think the best solution to the issues you identify?
Objection, leading.
So can you reframe the question so that it's not asking her to just confirm what you're asking?
Yes, I think if we hear the whole question. But no, I'll try again. In your expertise as the chief medical executive, do you have an opinion on whether the best solution to the issues you identified with Exhibit 4 is to say the patient should?
Objection leading.
Doctor, what is the best way to address the issues you identified with Exhibit 4?
By making none of that material mandated.
Is it an acceptable alternative for patients to sign a form saying they reviewed the materials when they didn't?
No.
Is it an acceptable alternative to give the patients the information?
Objection leading.
Whatever. Moving on.
Just ask her why.
Yes. Okay. Why?
I don't think there's a way to tailor that information in a way that it allows it to be applicable for everyone. If the material is freely available and patients want to access it, if providers want to use it, it's there. But I just don't believe that mandating it in all cases, especially when it could cause harm, is a reasonable solution.
And then a couple quick questions about the fetal information, the fetal images, and the conversation that you had with Mr. Tuttle about what evaluations might occur after the abortion. Just for the record, what is beta HCG?
It's a hormone that is produced during pregnancy.
And so could you please describe how a beta HCG test might be used to confirm whether an abortion is complete?
In some cases, not all, but in some cases, you monitor beta HCG going back down to 0 to ensure that termination has been complete.
Is it, in your understanding, is the fruit comparison meant to approximate the size of the embryo or fetus, or all the products of conception?
The embryo or fetus.
You were asked several questions about opioids, right?
Yes.
Does MDHHS respond to public health crises?
Yes, we do.
Was the opioid epidemic such a crisis?
Yes.
Is there any public health crisis these abortion laws are designed to fix?
Objection leading.
Actually not leading. Please continue.
Not as far as I can tell. And in fact, the crisis, the true crisis, is the maternal mortality crisis that we see in our country. And none of these obstacles in the path of women seeking reproductive health are designed to fix that crisis.
Could you please describe why how, if applicable, the maternal mortality crisis is related to abortion access?
The United States has the highest maternal mortality when compared to any other wealthy nation. And if we look at maternal mortality for Black and Brown women, it is several times higher than any other wealthy nation. By limiting women's reproductive access and choices, we are further exacerbating that.
You raised that you personally experienced distress from the material we've discussed today.
Yes.
Is it okay if I follow up since you raised it?
Okay.
You have publicly spoken about your own experience with a non-viable pregnancy, haven't you?
Yes.
Could you please tell us about the impact the materials had on you?
Yes. Hold on one second.
Take your time.
When I was at 20 weeks gestation, sorry, around 18 weeks, I was diagnosed with a pregnancy that I was told would be non-viable and that would end in likely fetal death. And because at that time there was still a heartbeat, I was told that I had to follow all of these protocols. And so even though I had seen my OBGYN 10 or 20 times at that point, and even though there was no real option for me to continue that pregnancy, I had to review those materials. And it was terrible for me. It was very emotional. I know that my physicians would not have shown me those materials if they didn't have to. And I hate for any other woman to go through what I went through.
Thank you, doctor. I'm very sorry that you had to go through that, and I have nothing further.
Thank you. Mr. Tuttle, do you have any recross?
No further questions, Your Honor.
Thank you very much. Thank you, Dr. Bagdasarian. You
Thank you.
are excused. Are just at about 2 o'clock. I know we have another witness for today. How would the parties like to proceed?
If we take a lunch break, Your Honor, could we take an abbreviated lunch break to try to finish the witness? She's made childcare arrangements that we've now had to change, and I know would very much appreciate, as we all would, being able to finish her today. We would be happy to take as brief a period of time as Your Honor would permit. Obviously, I want to let the court reporter, Lauren, who's been doing a great job, take a little break and stretch her fingers.
Your Honor, we believe an hour-long lunch break is adequate. Well, I don't expect to ask nearly as many questions of that witness as we have just now.
Take a full hour. We'll be at 3 o'clock by the time we come back. And I don't think that we'd be able to even finish correct examination of the witness in an hour.
Correct, Your Honor.
How much time did you run a half an hour? 45 minutes? Half an hour? Okay, let's take a half an hour break and come back at 2:30.
The Michigan Court of Claims is now in session.
Welcome back, everyone. Thank you for taking that abbreviated lunch. Please be seated. And I think we're ready to call our next witness.
Yes, Your Honor. Hillary Schneller from the Center for Reproductive Rights for the plaintiffs. And the plaintiffs call Professor Kate Spector-Baghdadi.
Swear or affirm under the penalty of perjury that the testimony about the witness. The whole truth and nothing but the truth.
Good afternoon, Professor Spector. Could you state and spell your name for the record?
Sure. My name is Kate Spector-Baghdadi, which is Kayte Spector hyphen Bagdady.
And you go by Professor Spector, is that right?
Professor, can you make sure that the microphone is close to you?
Yes, is that better?
Is that better? Yes, okay.
We'll
Is there a
try
way
to keep
tighten
an
it
eye
so
on.
that it, okay.
Lower myself.
I think that should be fine. Just-
Okay,
Yeah,
I'll just be,
perfect.
We'll keep an eye on it. So Professor Spector, what is your profession?
so I am a tenured associate professor of obstetrics and gynecology at the University of Michigan Medical School.
And you are currently employed at the University of Michigan Medical School. How long have you been there?
I've been at U of M for a decade now.
And in addition to being an associate professor of OBGYN, what are your other roles briefly at the U of M?
Sure. So I was trained in law and bioethics. And so at U of M, in addition to, as part of my associate professor role, I teach, I do research, I help run our Center for Bioethics and Social Sciences in Medicine. And as part of that, I oversee our clinical ethics consult service. And I also provide clinical ethics consults myself.
Okay, and you mentioned bioethics. What is bioethics?
Sure. So usually the term is used as a broad umbrella of different kinds of applications of, it's usually described as applied ethics to medicine and science. And some classic examples that fall under the umbrella include clinical ethics, which, as I mentioned, I have expertise in. Research ethics, and then public health ethics are often described as what falls under the umbrella.
And what is the relationship between bioethics and medical ethics?
So I would consider, I think often medical ethics is used synonymously with clinical ethics. The idea is that the ethics that are practiced in the clinic or between a clinician and a patient.
And you mentioned you are trained as a lawyer, and have expertise in bioethics. So what degrees do you hold?
So I hold a JD and a master's in bioethics from the University of Pennsylvania Law School and Medical School, respectively.
And did you complete any fellowships?
Yeah, so I completed a fellowship training at the University of Michigan, which both taught me about how to read and understand the scientific literature better as a policymaker, and also a specialty training in clinical ethics. So as part of that training, I shadowed and I have been involved in hundreds of clinical ethics consults during that time.
And do you have any credentials related to clinical ethics?
Sure. So the American Society for Bioethics and Humanities, which is one of my professional organizations, within the past 3 to 5 years, created a new certification for healthcare ethics consultation. And the idea behind the certification was to ensure that anybody who's offering themselves as a clinical ethicist in a hospital setting would have a certain baseline of both experience and credentials. And so in order to sit for that exam, you have to have hundreds of hours of experience in addition to passing a board certification. And I hold that certification as well.
Okay, so let's talk a little bit more about your role as a clinical ethics consult. Is that the right term?
Consultant, yeah.
Consultant at U of M. Can you explain what that means to be a clinical ethics consult?
Sure. So it means that for the University of Michigan Health System, we offer a 24/7, 365 consultation service, which means that any member of the healthcare team or any patient or any family member can page us anytime, day or night. And there will be a certified consultant who will answer that pager within 15 minutes and be at the hospital within 15 minutes if they need them, and offers on the ground consultation in medical decision making, in support, in better communication between the healthcare team and the patients and the families. And so as one of the 7 consultants that we have right now, I take about 2 months, 6 weeks to 2 months worth of call per year. And I also sort of oversee the program as leadership of the center.
And does your consult service focus on any particular area of medical care?
So in the middle of the night, we answer whatever page comes to us if it's an emergency. But generally speaking, my areas of expertise fall within reproductive health as well as genetics. And so if it's not an emergency, which at least genetics often isn't, if it goes to the next day, then I become involved in almost every single one of our reproductive health or genetic consults, as my colleagues who, for example, have expertise in surgery or have expertise in neonatology would get involved in those consults.
And what are some of the issues that come up in the context of a consult on reproductive health issues?
Yeah, so all of the ones that I can think of offhand have to do with informed consent. So for example, a number of years ago, and I can use this example because the family made the case public and it was reported in the news, we had a patient who came in for surgery for her brain cancer and found out she was pregnant. And she decided to continue on the pregnancy and to decline radiation services, which would have prolonged her life. And so we got involved just to make sure that her and her family were fully free from coercion and that her autonomous choice to continue the pregnancy was honored. Actually, there wasn't really a problem with it, but sort of as a backup, we became involved to ensure that her full autonomous choices were fully honored. Unfortunately, she passed, but she wasn't able to fully make that choice to pass away with her pregnancy.
For sharing that example. And so you're not a physician, right?
Correct.
So how do you stay up to date or informed about reproductive health that you're advising about in terms of the ethics consults?
Sure, lots of ways. So I do a lot of peer review where I get to read a lot of the latest and hopefully greatest materials. I subscribe to several journals that I read cover to cover. I go to many academic conferences throughout the year where you sit through 4 days worth of presentations. And I also travel a lot because many experts are on the coasts. And so I spend a significant amount of time on the East and West Coast catching up with peers at other institutions to make sure that I'm up to date and on the latest information.
And you also mentioned you're an associate professor of OBGYN at the U of M.
Yes.
What do you do in that role?
As an associate professor, so as I sort of mentioned, we describe it as effort, like how my effort is covered. So part of my effort is leading the Center for Bioethics. A large part of my effort is doing research on better practices, including research on how to improve informed consent by talking to thousands of patients and practitioners and researchers. And then, as I mentioned, I also provide clinical ethics consultation and I teach informed consent to our medical students specifically who are either in their OB-GYN clerkship rotation, which means the first time that they're on the floor providing or at least seeing OB-GYN services. And I also teach all of our medical students who are going to go on into OB-GYN residencies. I teach them a specific class on getting informed consent in reproductive healthcare.
And where were you working before you joined U of M?
Before I joined U of M, I spent 5 years working for the U.S. Department of Health and Human Services. I was the Associate Director for the Presidential Commission for the Study of Bioethical Issues under President Obama.
And you also mentioned you do research in the field of bioethics. What does that research focus on?
Sure. So it focuses on a number of subspecialties, including I do a lot of work in the history of medicine. I do work in reproductive health. I do work in informed consent generally. And then I do a lot of work in building health data governance systems with data from patients or research participants to ensure that those systems are built in a way that is consistent with patient understanding and informed consent.
And you also publish in the field of bioethics?
I do.
What are some examples of journals in which you've published?
Sure. So I have published in the highest impact journals in many different subspecialties, including obstetrics and gynecology, or the Green Journal, Health Policy, which is Health Affairs, Bioethics, which is the American Journal of Bioethics, where I'm also an associate editor, History of Medicine, like Milbank Quarterly, and then almost all of the major academic medical journals as well, including the New England Journal of Medicine, JAMA, Nature Medicine, Places of Science, places like that.
And I think you mentioned you are a member of the American Society of Bioethics and Humanities.
I am.
Have you held any leadership roles in that body, society?
Sure. So during COVID, I was, and I just say that to place it in time for us, but I was elected. It's a full membership election to be a director on the board of directors of the American Society for Bioethics and Humanities, which, as I mentioned, is a place that certifies clinical ethicists.
All right, so I'd like you now to turn to Plaintiff's Exhibit 1, which is the law in this case. Say one of the laws being challenged in this case. Generally, what is your understanding of what this law requires?
My understanding of what this law requires is that our department, meaning Michigan's Department of Public Health, is required to develop materials as defined by this law and provide them to patients seeking an abortion specifically.
And do you also understand that this law includes a 24-hour mandated delay between when patients receive that information and when they can access the abortion?
Leading.
I'm just trying to establish the basics of the law so we can move along.
I'll allow it.
Thank you.
There is also a mandatory 24-hour wait period as part of this statute.
And you were asked to provide expert opinions in this case, correct?
I was, yes.
And how did you prepare those opinions?
I prepared those opinions by reviewing the statutes at issue. I prepared those opinions by preparing an affidavit and reviewing some historical informed consent cases. I reviewed the state's produced mandated materials. I reviewed the affidavit of Dr. Farr Carlin, who is the other bioethicist on this case. So those kinds of materials.
So turning first to the 24-hour mandatory delay provision, do you have an opinion on whether this provision is consistent with informed consent?
I do have an opinion, and it is that this provision is not consistent with informed consent.
And can you explain briefly why that is?
Sure. So there's no evidence whatsoever, either in the medical, scientific, or bioethics literature that ties waiting 24 hours to improved informed consent.
And turning then to the state mandated counseling information part of the law, do you have an opinion about whether that part of the law is consistent with informed consent?
My professional opinion is that it is not consistent with informed consent.
And why is that?
So for several reasons. So as we discussed earlier this morning, there are a couple of elements of informed consent that one must adhere to. Those include, one, ensuring that the patient in front of you has capacity to consent. 2, that they have the appropriate information in order to use that capacity to apply that information to their own values to make the best decision for themselves. And 3, that they are free from coercion. And in specific application to this law, 1, it requires that patients either receive or acknowledge having reviewed information that is either not relevant to them or incorrect. And specifically, when I say incorrect, I'm talking about the provision that specifically states that in the statute that as a result of an abortion, that patients may experience an increased risk of things such as depression.
Okay, so we will get into the weeds of some of those provisions in a bit. But just to take a step back, what is the key goal or purpose of informed consent?
Sure. So as I mentioned, the key goal and purpose is to, 1, make sure the patient that you're talking to has capacity. And this could either be because the person's a child that they don't have capacity or legal capacity to consent, or because they're under some other kind of either permanent or temporary incapacity or effect on their ability. Second is to ensure that if the patient has capacity, they have the right kind of information to use that capacity to make a choice that aligns with their goals. And generally, that kind of information is defined as the relevant risks, benefits, and alternatives of the intervention. And third, the third element is freedom from coercion or free choice.
And so just picking up on freedom from coercion, can you explain coercion from an ethical perspective?
Sure. So it's always hard to prove a negative. But when I teach this to our OB-GYN students and our medical students generally, what I teach them is to be alert to any sort of signs that the patient may be being coerced. So, for example, if they have a partner or a family member in the room, if they keep glancing at them before answering questions, if they're shaking, if they're sweaty, if there's physical indication of harm to them. These are all things that we train all students to be aware of when getting informed consent. And that's across the board, not just our OB-GYN students, but also any of our medical students getting consent for any kind of intervention.
Now, for context, can you tell us a little bit about how the doctrine of informed consent developed through the court system?
Yeah, so it's really interesting. Well, to lawyers who are interested in medical history. So originally around the turn of the century, it actually started as an assault or battery or trespass claim, because before the turn of the century in the US, it was very much expected that doctors would be very paternalistic and do what they thought was in the best interest of the patient without asking the patient, or perhaps asking the patient's husband if the patient was female, but not them. And so some of the famous original court cases were created to actually establish a right to informed consent to begin with. So if somebody was going to intervene in your body, they had to ask your informed consent. And then in the 50s and 60s, really responsive to the civil rights movement and movements of the time establishing people's choice and freedom of choice and autonomy in their own bodies, it moved more to a negligence-based standard, which is where it remains today, where it was accepted that obviously there'd be informed consent before you perform an intervention on my body. But then it started to focus on exactly what kinds of information were required to ensure that you didn't just consent, but that consent was informed.
And just to, you mentioned asking the husband in the context of the trespass cases. Did most of those cases you're referencing involve procedures on men or women?
Yeah, so actually, interestingly, many of the most famous informed consent cases especially establishing a right to informed consent, involved women. And I think one of the reasons for that was it was traditional to act in deference to the husband's wishes. And so, or to the man's wishes, so it wasn't as much of a problem because that was obvious to have that kind of conversation when you're intervening in a man's body. So many of the classic cases at that time establishing this interest in informed consent involved women and actually often involved reproductive health.
Fast forwarding to today, you mentioned the negligence standard and what is required as part of disclosure in informed consent in the context of that standard?
Yeah, so talking about information specifically. So as I mentioned, what's required to be disclosed is either sometimes the term material, sometimes the term relevant is used in the court cases, but material risks and benefits, as well as alternatives of the intervention that's being discussed.
And you're using the term material and relevant interchangeably?
I am, and often it's used interchangeably by the court system.
Okay, and what do you mean by material risks and benefits?
So there are a couple of different definitions. A classic ethics definition would be information about the risks, benefits, and alternatives that are relevant to the patient making an autonomous choice, which is a bit circular, philosophers. But a court example of the definition is also similar in that sort of talking about the risk, benefits, and alternatives where the patient can make an informed choice that sort of reflects them as an autonomous human being. So if I'm able to express my values, because people have very different values when they're making interventional choices, then I have received enough information about the risk, benefits, and alternatives that are material to me.
And so how did the patient's values or goals figure into the discussion of alternatives to the intervention?
Yeah, so one thing that we look at when we're talking about relevance is presenting information that is tailored to the individual patient in front of us, as well as responsive to their values and their goals that we know about. So, for example, if a patient was presenting to an abortion clinic, for an abortion, we might talk about sort of different kinds of alternatives that were appropriate for the individual patient for that abortion.
And do ethics inform the standard of care for informed consent?
Yeah, the standard of care is one of those terms that's used by different disciplines, sometimes a bit differently. But doctors and clinicians generally use the term standard of care to mean what are best practices in the clinic. Then also, I'm sure as the court knows, legally, there can be an established standard of care for medical malpractice cases, which can be somewhat a bit different than what clinicians would describe as best practices. But for the purposes of this, I'm happy to continue using standard of care, describing what clinicians do in practice.
And if a clinician fails to obtain proper informed consent prior to performing a procedure, can they face discipline?
Yeah, there's lots of different kinds of disciplinary levels. So, for example, if a doctor fails to obtain informed consent and the patient suffers from an injury that was not disclosed, for an example, the doctor might be held liable in a medical malpractice suit. There are also checks and balances at the hospital level. So, for example, I'm there actively teaching medical students and sometimes practitioners how to get informed consent. If anybody's concerned that informed consent has not been gotten or received, they can page ethics. The attending is responsible for ensuring that trainees and residents get informed consent. The hospital administrator is responsible for ensuring that the attendings get informed consent, and there are professional organization standards. So we often describe patient protections like this as Swiss cheese. It's hard to ensure that any layer has no holes, but if there are enough layers of protections for patients, they're very unlikely to fall through.
Okay, so I'd like to now apply these principles that you've been discussing to the laws challenged in this case. So I think you're still on Exhibit 1. So I'm going to do my best just to orient us because there are two subsections that sort of cross-reference each other. So let's look first at subsection 11, which is on page 3. Let me know when you're there.
I am there.
Okay, so do you see subsections 11A and B?
I do.
They say that the Department of Health shall publish certain information.
Yes.
Okay. Then turning back to the bottom of page 1, crossing over to page 2, subsection 3. Oh, it starts on page 1.
Oh, sorry.
Sorry, I know a lot of numbers.
Yep.
And then if you look at subsections 3C
Mm-hmm.
through 3E, which crosses over onto the next page,
Yes.
that says at least 24 hours prior to an abortion, a patient must be provided with information published by the Department of Health, including standard information about the abortion procedure they will receive, image of the fetus at the patient's probable gestational age, and prenatal and parenting information.
Correct.
So let's turn back to subsection 11, which is on page 3, and take these one by one.
Sure.
So looking at 11A, which says the department shall produce images of the fetus at 2-week intervals from 4 weeks through 28 weeks gestation. You see that?
I do see that.
In your opinion, is requiring patients seeking abortion receive fetal development images consistent with informed consent?
It is my expert opinion that this is not consistent with informed consent.
And why is that?
Well, for a couple reasons. So very few, if any, I think none, no patients are receiving abortions at 28 weeks in Michigan that are elective. And two, a picture or an image of what is coming out of a patient's body is not relevant to informed consent. So, for example, if a patient is in for an appendectomy, we don't give them a picture of a gangrenous appendix in order to ensure that they want it out. Or a patient with a tumor, we don't give them a picture of the tumor to decide whether they want it out. And so it's very abnormal. And this is the only case I can think of that a picture of what's coming out of somebody's body would be considered relevant or necessary to inform consent.
Okay, and are you aware of any Michigan law that requires patients seeking prenatal care be provided with fetal development images?
I'm not aware of any such law.
Or any law requiring that for patients seeking fertility treatment?
I'm not aware of any such law.
If such a law existed, do you have an opinion about whether it would benefit patient-informed consent?
Again, I don't think a picture is relevant to either the choice of ending a pregnancy or continuing a pregnancy, but as discussed at length this morning, the informed consent process is supposed to be individualized. And so certainly if there was a circumstance where a patient requested a picture, either before a termination or before labor and delivery, it would be best practice for the OB-GYN to do their best to direct them towards any such imagery. Because again, the point is to be individualized and responsive to the patient's needs.
And let's now look at, still on page 3, subsection 11B, little 1, which says the department must publish standard summaries describing abortion procedures. Do you see that?
I do see that.
And so is requiring patients be provided with state published standard summaries of abortion procedures consistent with informed consent?
It is not consistent with informed consent.
Why is that?
So for two reasons. One, as we discussed before, The benefits, risks, and alternatives are supposed to be those that are relevant and material to the patient. And different kinds of interventions might be more or less appropriate for a patient depending on sort of existing comorbidities. Again, there's an entire segment of patients that are pregnant with a non-viable pregnancy. So risks and benefits of labor, for example, are not relevant to them. And so this is the whole point of an individualized consent process, because all risks, benefits, and alternatives can be very different across different patients. And so presenting patients with a one-size-fits-all document fits no one. It requires that practitioners both provide information that is not relevant and, as I described before, can be inaccurate, not only in application, but to anyone. Like, for example, as a result of an abortion, patients are at increased risk of depression.
All right, so let's, we will get to that one. I'm trying to keep us in order so that the record
Sorry.
is clear. No, don't apologize. So let's go next to subsection 11B(2), which says the department must include information about the physical complications of each abortion procedure as well as live birth. So is requiring patients receive that information consistent with informed consent? And if the reasons are similar to what you've already discussed, you can let us know.
I'm sorry, I'm having trouble hearing.
Oh, sorry.
What was your question?
Is requiring patients receive the information that's in 11B(2) consistent with informed consent?
So it's not consistent with informed consent, and I can give you two reasons. So the first is to describe the risks and benefits of each procedure described in subparagraph 1 is not consistent because, as we just discussed, for example, a live birth is not an alternative for everyone. Different kinds of abortion interventions are not necessarily alternatives for anyone, depending on my underlying comorbidities. For example, I think the example that was given already was a higher risk for a blood disorder and for hemorrhage. They're different. Also, we only have to look to patients who are consenting to live birth to understand that it's not consistent with practice, because when a patient comes into prenatal care and is preparing for, a hoped for live birth, we don't talk to the patient about an abortion. We don't sit down and disclose the potential benefits to the patient of an abortion. And in fact, I would hazard a guess that if an OB-GYN sat a patient down who was coming in for prenatal care and said, "Hey, have you thought of abortion? Here are some of the benefits of abortion," that my pager would immediately go off. And I would have to go and help that team communicate more effectively because it's inappropriate.
And when you say inappropriate, what do you mean by that?
I mean, it's not consistent with informed consent standards. And in some cases, not only can be not consistent, it can be inaccurate, and it can also be cruel. Like, for example, the situation where we discussed where a patient is not experiencing a pregnancy that can ever result in a live birth, to go through alternatives that are not relevant to that patient and actually might be very sad and hard to hear for that patient. Not only is not relevant, but it can serve to harm the patient emotionally and also damage the physician-patient relationship.
So just jumping down to 11B(4), which instructs that the department materials state that, quote, "Not all complications listed in some subparagraph 2 may pertain to the particular patient," and directs the patient to speak with their physician for more information. Does that change your opinion that you just discussed about the harms of subsection B2?
It does not change my opinion.
And why not?
It doesn't change my opinion because it is, one, not consistent with informed consent, in which risks, benefits, and alternatives are supposed to be tailored to the patient, but also it's incredibly confusing for the practitioner or the practitioner's administrator to tell the patient that there are materials that are produced by the state that they have to review before 24 hours in advance before accessing abortion, and then to just have a sentence in it that says, just kidding, these aren't relevant, not only is very odd, but serves to undermine the entire informed consent conversation when they get in, because then it might and very likely will put the doctor in a position where they have to go through and say what's not relevant to them. And so from the get-go, it puts both the doctor and the patient in sort of an awkward and uncomfortable position because you're already outside of the auspices of informed consent.
And you've already touched on 11B3, which relates to the disclosure that as a result of an abortion, some individuals may experience depression, feelings of guilt, sleep disturbance, loss of interest in work or sex, or anger. Briefly, can you share why that is inconsistent with informed consent, as you've already testified?
Sure. So this is not consistent with informed consent because this has not been proven, and in fact has been disproven by the medical literature. So in the best designed study in this space was the Turnaway study, where they were able to compare women who wanted an abortion and had access to an abortion to women who wanted an abortion but were prevented from accessing an abortion. And that was an important control group. So that's the group that you compare the intervention to, because there have been other studies that have looked at women who want to be pregnant and want to have a baby, and compare them to women who didn't want to be pregnant and didn't want to have a baby. But the classic problem with that is a problem between causation and correlation. So just because two things can happen together doesn't mean that one happens because of the other. And so in this very carefully designed Turnaway study, they established that when you compare apples to apples, it is not actually true that as a result of an abortion, patients may experience depression. It is not as a result of an abortion. Patients may experience depression after any number of things that happen, like, for example, breaking up with their boyfriend, having a vasectomy, but it is not caused by the intervention.
And are you aware of any Michigan law that requires patients seeking prenatal care be provided the same disclosure about risks of depression, feelings of guilt, sleep disturbance, et cetera, during pregnancy or postpartum?
No, I'm not aware of any such law.
I'm going to now have you jump back to subsection 3 on pages 1 and 2. And we'll go to subsection 3E, which is actually on page 2, but 3E states that 24 hours before an abortion, a person seeking an abortion must receive a physical copy of the prenatal and parenting information packet distributed by the Department of Health. Do you see that?
I do see that.
So is requiring every patient seeking abortion receive information about prenatal care and parenting consistent with informed consent?
It is not consistent with informed consent.
And is that for the reasons you've discussed already?
Well, yes, and prenatal care is not an alternative to an abortion. An alternative to an abortion might be continuing to have a live birth, which might involve prenatal care, or it might be that the fetus is never going to result in a live baby, in which case it would be not relevant and not consistent for that patient.
I think we heard this morning, but are you aware of any Michigan law that requires the prenatal and parenting packet be given to people seeking prenatal care?
No, I'm not aware of any such law.
And you've mentioned a few times that some aspects of the Department of Health materials, or at least what the statute requires the Department of Health materials to include, some of it is inaccurate information.
Correct.
if the state mandated materials contained only accurate information, would that change any of your opinions?
It wouldn't, because the depression sentence that I brought up is inaccurate in all circumstances. But if we have a one size fits all consent form, it is going to be inaccurate in many circumstances, or even all circumstances, because you're giving all patients the same risks, benefits, and alternatives that might or might not apply to them. But if you're giving them all at once about all of the different kinds of interventions, clearly it can't apply to any of the patients, because a patient isn't getting 3 different kinds of abortion at the same time.
And I think Dr. Bagdasarian was asked whether, the problems with the Department of Health materials could be addressed if the patient just tosses the Department of Health materials in the trash after receiving it. Do you have an opinion on whether that resolves any of your concerns about the challenge laws?
No, that doesn't resolve any of my concerns, because presenting a patient with information and then expecting them to, or asking them to, throw it in the trash is not only not consistent with informed consent, but actually undermines the entire physician-patient relationship to begin with. Because why would we give them a piece of information from the state that they're required to sign if they access it online, and then tell them to discard it and just throw it away? It doesn't even make any sense.
So I'd like to now talk a little bit about how the state mandated information laws for abortion compare to other Michigan statutes regarding informed consent. So other than for abortion, are you aware of areas of medicine in Michigan where informed consent is regulated by statute?
Yes, I am.
What is one of those areas?
An example would be genetic testing.
And if you can turn to Plaintiff's Exhibit 261, which has been admitted.
Yes, sorry.
Is this the genetic testing statute you're referring to?
This is the genetic testing statute I'm referring to.
And generally, what do you understand this statute to require?
Generally, my understanding is that this requires the state to produce an informed consent form that addresses the material risks, benefits, and alternatives of a genetic test.
And do you understand that clinicians are required to use that form?
So they are not required to use that form. What the statute says is that if the practitioner does use the form, the patient is later barred from substantiating a claim for a lack of informed consent. So it's an affirmative protection for the practitioner, as opposed to a state mandated informed consent.
Okay. And at this time, I'm going to ask the court take judicial notice and admit Exhibit 252, which I have copies of. So I'm going to give you the copies and then I will continue.
May I add one more thing to your last question?
Sure.
Okay. So the other thing that's different about the genetic testing informed consent statute is that it explicitly states within it, under subsection 7, that a physician's duty to inform a patient under this section does not require disclosure of information beyond what a reasonably well-qualified physician licensed under this article would know. And so even within the statute itself, it refers back to the clinical standard of disclosure.
So before we continue with Exhibit 252, just because you mentioned that, if the challenged abortion law here included the same statement, would that change your opinion about the state mandated information?
No, it wouldn't, because again, so in this statute, it says that it's not intentionally trying to change the physician's knowledge of what risk benefits and alternatives must be disclosed. But to go through an entire list of state mandated risk benefits and alternatives that are not relevant, and then to say at the end, just kidding, again, doesn't make any sense.
Thank you. So I'm going to turn back to Exhibit 252 and ask the court to take judicial notice under Michigan Rule of Evidence 202B, which requires the court to take judicial notice of statutes in force. And Exhibit 252 is MCL 333.5654 through 5656, a statute about informed consent surrounding terminal illness. We provided notice to defendants that we might use this exhibit when we exchanged exhibit lists a few weeks ago. And the court has already taken judicial notice of several other statutes as we asked in our motion earlier. And we're requesting the court admit Exhibit 252 at this time to respond to some questions about Exhibit Q, which was the pamphlet around care surrounding terminal illness.
No objection, Your Honor.
So admitted. Continue, please.
Thank you. May I approach the witness with? Thank you. All right, so Professor Spector, do you recognize this document?
I do, yes.
And in general, what is your understanding of the Department of Health's obligations under this statute?
Sorry, just a point of clarification. Are you only asking about one of these statutes, or are you asking about all of them?
Well, it's a set of sections, so questions may come up about the 3 sections that are here. So it's.
I'm not trying to be difficult.
Yeah.
You had just said you recognize this document, and then you said the statute. So
Oh, okay, sure. I can clarify. So Professor Spector, if you go to page 5 of the document, if we look at section 333.5656, what do you understand the Department of Health's obligations under this part of the law?
This part of the law says that the Department of Health shall develop and publish an updated standardized written summary that contains all of the information required under 5655.
Looking at the 3 sections together, what is your understanding of what providers are obligated to do with the Department of Health materials?
My understanding is that providers can use those materials if they deem them appropriate for the patient in front of them.
And how does this set of laws compare to the statute challenged here?
Sure. So it's different in several regards. So one important difference is that, again, there is the disclosure that this statute does not. So sorry. So this is in 0.5654, section 2. There is a clarification that the physician's duty to inform a patient under subsection 1 does not require the disclosure of information beyond that required by the applicable standard of practice, which again is individualized risk benefits and alternatives. Second, it doesn't require that the practitioner provide the patient with the state created informed consent information. And third, and this is a little bit of a nuanced distinction, but I think it's worth making, that when a patient presents at the end of life, there is not an option to not die. Right. So just because a patient is presenting for end of life care, there is a conversation about alternatives to how their lives will end that's appropriate, but it would not be appropriate for the doctor to say, but would you prefer not to die? Because that's not actually an alternative in this case. And so I think that Again, it's a little bit nuanced, but I think it's an important distinction that sort of helps describe why those alternatives are appropriate in this case and why the alternatives are not appropriate in many of the cases in which they're used in the abortion disclosures.
And you can set that aside. I'm going to shift gears a little and ask you about the 24-hour mandatory delay provision in particular.
Sure.
So earlier you testified about the key components of informed consent. How does autonomy figure into the requirements of informed consent?
Sure. And not to scare anyone, I'll just say one thing about Kant. So it is all derived from sort of the Kantian principle of respect for persons. And the way that we respect people in medical care is by respecting their autonomous interests if they have capacity. And then the way we respect patients' autonomous interest is by getting their informed consent. So that's sort of like the higher level derivation of how we get to informed consent is important to respect people's autonomy, which is important to respect people overall.
And in your opinion, does the 24-hour delay provision serve patient autonomy?
No, it's entirely irrelevant to patient autonomy and also serves to undermine patient autonomy insofar as the patient's autonomous choice is to access abortion by one, presenting a procedural or logistical burden in between when the patient makes that choice and accessing abortion, and also by undermining that choice by presenting information that is not relevant or inaccurate.
And do you have an opinion about what the 24-hour mandatory delay provision conveys to patients about their capacity to make decisions?
Yeah, so I think that there is a lot of nuance and implication that harkens back to many of the cases at the turn of the century where we assumed that women were not autonomous beings and had to be told that they really needed to think about their choices because we didn't believe that they could make a medical choice in the same time period as a man could. And so I think it very much indicates one, that are you really sure about this choice? And also like, well, you need to think about this more. And as we mentioned, if a woman comes in for labor, we don't send her home and say, you should really think about whether you're want to have this baby. If a woman presents for prenatal care, as I already testified, it would be inappropriate to say to her, have you thought about abortion? Why don't I send you home for 24 hours so you can think about an abortion? It would be very inappropriate. And again, I would be paged and that would be reasonable. And so it just makes no sense in this context.
And you testified earlier about the genetic testing statute and the statute Exhibit 252 around terminal illness. Did either of those laws have any state mandated delay period?
No, they did not.
And are you, as we discussed, I think you heard Dr. Bagdasarian's testimony earlier about the Medicaid rule for a 30-day period before sterilization.
Mm-hmm. Yes.
And are you familiar with that requirement?
I am familiar with that requirement, yes.
And do you have an understanding of why that Medicaid rule exists?
Yes, I do. So the reason that Medicaid rule was specifically passed was because we have a long and unfortunate history in this country of coercing women that we see as undesirable to reproduce, specifically women of color. And women that were seen to lack capacity. And sort of the famous Supreme Court case is Buck v. Bell, which they based on Jacobson v. Massachusetts, having to do with the vaccination the mandatory vaccination. And in that, the Supreme Court actually argued that 3 generations of imbeciles referring to the pregnant Carrie Bell is enough, and that the public health laws that justify vaccination are enough to justify forcible sterilization. And so not only this has been overturned since then, but not only was that the law of the land that forcible sterilization without consent was allowable, but there were also many specific cases in which practitioners were found to coerce, again, mostly women of color into getting sterilization. So one of the classic cases is in the California penal system, where women who were in labor, largely who were Spanish speaking, were presented with English informed consent forms before being able to access pain medication for their labor. And in that stack of informed consent forms, it included a consent for sterilization. And so these women were being coerced and were entirely unintentionally signing consents for sterilization. And then if they went in for a cesarean section, they were forcibly sterilized. And many of them didn't even realize that they were sterilized until they went to have another child and they presented for fertility assistance. And so the 30-day wait period in the Medicaid law was actually didn't assume anything about 30 days being related to an improved decision on whether to be sterilized or not. It had to do with protecting patients from coercion by practitioners, which I think was unfortunate because the best way to protect patients from coercion from practitioners is education and preventing that coercion, as opposed to putting a 30-day barrier between a patient and a wanted sterilization.
And so do you have any opinions about how the Medicaid mandatory delay impacts patients?
Yeah, so while it was mandated in response to a well-known problem that I certainly validate, at this point, it also serves to prevent access to wanted sterilizations. And actually, many OB-GYNs and ethicists have advocated against it. It also systematizes disparate access for patients who are on Medicaid because our privately insured patients have no such delay, which means that in practice, if a patient can afford private insurance, they don't have to wait 30 days. But if a patient is on Medicaid, they do, which creates both barriers and disparate access to care at the state and federal level.
And so we've just been discussing the 24-hour mandatory delay provision. Earlier, you testified about the state mandated information. So I want to bring those two provisions together and ask you, do you have an opinion about how those provisions operate together?
The provisions, the 24-hour wait period, and then what must be disclosed.
Correct.
Sure. So it's very unfortunate and entirely opposite from the intention of individualized informed consent to force a patient to read either inaccurate or not relevant information and then sit with that information away from their practitioner for 24 hours before they can ask their practitioner for clarification. So there has been a lot of research that's been done on best ways to get informed consent. And by that, I mean to measure patient understanding. And what that has found time and again is that it's actually the informed consent conversation. And so if you force, require, etc., a patient to read information in a situation where they can't have that informed consent conversation, not only is it undermining to the clinical standard of care, but it's undermining to all research about what works for informed consent.
And do you have an opinion about how it can impact patients?
Sure. So, I mean, it depends on the patient, right? So as we've discussed, many pregnancies will not result in a live birth. And so if the patient is left with information about what her live birth might look like, how she should put any resulting baby to bed, under those circumstances, not only is it not relevant, but it's inhuman and cruel. And in the best of circumstances, we're presenting information that is not tailored to the person who's reading it, who might, for example, I mean, patients get very confused with informed consent, the written informed consent. So I do a lot of research on informed consent, and time and again, what I find is that patients don't understand a lot of the nuances. So to expect a patient to understand the difference between the different kinds of interventions, and they might only receive one, is a lot to expect of a patient. And a lot of patients fixate on sort of the biggest risks possible and get concerned that that applies to them. And they might not even present for the informed consent conversation with the practitioner because they feel like they understand the procedure to be much riskier than it actually would be for them.
No further questions at this time.
Okay, thank you very much. Next exam. I just say, Professor Bajati, do you need a break at all?
I'm good.
Okay.
I certainly do.
Mr. Tuttle, also before you begin, we do have to adjourn court at 4 o'clock today because just court logistics. And I just want you to keep that in mind in terms of where you want to break or think is an appropriate time for that, because then I think your testimony will have to continue tomorrow. Unless you
Well,
think you can finish in half an hour.
I would hope so, but I just don't know for sure,
Okay.
Your Honor. I mean, it's since it's only half an hour, can we just break and then just start up on cross tomorrow?
Our request would be if there's a possibility we can finish, let's please try to do it. The witnesses have changed their schedules and we're really doing our best, but it would be great to use as much of the court time. We've taken a huge number of breaks at intervening defendants counsel request. If we could just get started, we'd all really appreciate it.
Let's get started and see how far you get. If you need more time, we'll come back tomorrow. Recall the witness.
All right, thank you, Your Honor. Good afternoon.
Good afternoon.
It's good to meet you in person.
It's good to meet you in person.
It's correct that you have not received any abortion training or viewed an abortion procedure, correct?
I have been present at the end of an abortion procedure, which occurred during my shadowing of OB-GYN practitioners as part of my clinical ethics and general orientation to being faculty.
Oh, when was that?
It would have been when I was a fellow, so 9 or 10 years ago.
And you have advised an abortion provider on informed consent for abortion in the range of 5 to 10 times, correct?
Yeah, so I think that the number of consults that have come to the committee that I'm on and the service that I oversee is much larger than 5 to 10, but I answered the pager on about 5 to 10 cases, yes.
Isn't it true that alternatives to a procedure include not undergoing the procedure?
So in some cases, alternatives to a procedure can include not undergoing the procedure. But for example, in the case of a non-viable pregnancy, to not undergo a termination could very well result in the patient's death. So that's generally not what we would see as an alternative to a procedure is dying, but sure, under some circumstances, patients choose to die, like the example that I gave you, where the patient decided to continue her pregnancy and forego cancer treatment.
I'm sorry, did I understand you correctly? You said that if someone has a non-viable pregnancy, then the only alternative other than abortion is to die?
No, I'm sorry. Under some circumstances, like for example, if the pregnancy is ectopic, it can result in hemorrhage, which might result in the patient's death, but certainly we would expect and hope that they present to the hospital and that we would be able to save the patient.
Do you know the rate of ectopic pregnancies?
I don't.
Probably didn't pronounce that correctly.
Ectopic.
Ectopic.
No, I'm sorry. I don't know offhand.
Do you know the rate of fetal defects incompatible with life?
Do I know the rate of patients that are pregnant with fetuses that are incompatible with life in the state of Michigan.
Yeah.
No, I do not offhand. I do know that about half of pregnancies result in like a spontaneous miscarriage. But I don't know, like, of that component, which of those miscarriages were, I guess all of them would be incompatible with fetal life if you miscarry.
Okay, so am I correct to understand that when you take that figure, you're saying that absent the individuals who have abortion, because we're not looking at those miscarriage rates because they don't miscarriage, correct? Right? Someone with an abortion who has an abortion procedure isn't miscarrying, right?
Well, sometimes an abortion is the appropriate procedure for somebody who is miscarrying.
Okay, so
It's the same kind of procedure in some cases.
well, I understand that there's some miscarriage management. There's been
Mhm.
testimony today that there's some miscarriage management that is similar to an abortion procedure.
Correct.
Are you saying that a abortion is the same, like a miscarriage is an abortion?
Well, sometimes they're referred to as spontaneous abortions if somebody has one at home. Yes, that is correct, that they are sometimes referred to as spontaneous abortions.
Okay, but I'm speaking of individuals who receive an abortion procedure from a medical provider.
Okay.
Do you distinguish them from the individuals who have spontaneous abortions?
Do I distinguish them in the context of your original question, which is asking the rate of pregnancies that are not compatible with life?
I just want to know if you see those things as different. An abortion procedure, be it medication or surgical or procedural, and a spontaneous abortion. Do you see those as different?
Well, yes, they're different. One happens spontaneously.
Okay. And the spontaneous abortion is sometimes called a miscarriage.
Yes. Mhm.
Okay. Would you ever call an abortion a miscarriage?
Or call an abortion a miscarriage. If something is a spontaneous abortion, it is synonymous with a miscarriage.
No, I'm sorry.
Okay.
So when I use the term abortion without the word spontaneous, I'm referring to a medication or procedural abortion.
Okay.
Would you ever call them a miscarriage?
Would I ever call a medication or a surgical abortion a miscarriage?
Yes.
Personally, no.
Okay. So I believe you testified that about half of pregnancies end in miscarriage. Did I hear that correctly?
That's my understanding of the literature, but I'm not a doctor.
Okay. Isn't it true that for many medical procedures, there are generally accepted risks, benefits, and alternatives that would be expected to be disclosed?
Sure, as long as they're tailored to the individual patient, because as I described before, many patients have underlying comorbidities that very much affect risk benefits and alternatives that are available to them.
All right. So, but there is generally accepted risk benefits and
Yeah, in many circumstances, there are
Right.
things that we would generally cover, yes.
my goal is to get through this before we have to break.
Mine too.
Yeah, it would be very helpful if you kept to direct answers. I understand you may want to qualify, but
I'm sorry, I was answering your direct questions with
Yeah.
direct answers.
okay.
Okay.
All right. So isn't it true that for medical procedures, there is a threshold or floor of information that has to be disclosed to every patient who's considering the procedure?
Every patient should receive individualized risk benefits and alternatives, yes.
Isn't there a floor of information though? That's generally accepted for each procedure?
Well, there's a floor of information if it's individualized, but it wouldn't make sense, for example, for you to talk about the risk of a live birth to a patient who's pregnant with a
I
non-viable
didn't say that
fetus.
though, right? I'm just talking about the general idea of a floor of information that is generally accepted as necessary to disclose.
As long as that floor is individualized.
Okay. And so it's true in almost any circumstance that you can think of that the patient is provided access to all the information that is generally expected to be disclosed.
So if we're talking about the legal standard, the standard is generally what the reasonable practitioner would disclose. If we're talking about a clinical standard, generally people describe it as best practice.
So for instance, for abortion, medication abortion, is hemorrhage a known risk for medication abortion?
It is more or less of a risk depending on the patient's underlying comorbidities. So especially if the patient had a blood disorder or I think some iterations of obesity are related to your risk of hemorrhage. And so yes, it would be very relevant to discuss that.
So, but isn't it true that hemorrhage is a risk for every woman who would undergo a medication abortion?
I'm not a doctor and I don't think I have specific expertise in that. I would take it at face value if you said it, but I'm sorry, I don't have expertise in the risk of hemorrhage across all women seeking an abortion.
So it's not the case then that you know that there are risks that are generally expected to be disclosed for every patient for a procedure such as medication abortion.
So every patient should get individualized risk benefits and alternatives.
So to be clear though, a doctor could look at risks, benefits of medication abortion, and one of which you acknowledge, just textbook wise, hemorrhage is a risk for medication abortion, right?
Okay, I'll accept it if you want to say that, yeah.
Oh, you don't have the expertise to know that?
I don't have the expertise to know the individual hemorrhage risk for different kinds of abortion for different women, depending on their comorbidities, no.
Okay, so when you provide a consult for medical ethics for informed consent, do you then consult with another doctor to learn what the generally accepted disclosure risks are?
Well, so I don't give medical advice as a clinical ethicist. And so my advice would look like you should tailor risk benefits and alternatives to the patient. And I can work with the clinician and with the patient and the family to make sure that they understand those components and that they're being effectively communicated. But I would not advise that the practitioner, for example, advise the patient that there's a 3% risk of hemorrhage. That's outside the scope of my practice.
Okay, so you're pretty much a communication specialist between the doctor and the patient.
No, I'm an ethicist,
Okay.
which is its own certification and
Okay.
specialty, but
So,
involves improved communication.
yeah, so, but you don't have any expertise to know what disclosures should be made in terms of particular procedures.
So I don't advise individual doctors about what specific risks should be disclosed to individual patients because that's up to their clinical assessment of the patient and their individualized risk profile.
Okay, so is that a yes?
I'm sorry, to what question?
You,
I don't advise doctors to disclose a specific percentage risk of miscarriage.
you can't judge at all whether the certain disclosures meet medical ethic requirements for that procedure.
So I can judge the standard to which we should adhere, but I don't apply it for individual practitioners and say that it needs to result in a specific risk benefit or alternative. That's outside the scope of my practice.
Okay. So you don't know that for any particular procedure, whether there is any generally accepted threshold of information?
I mean, the generally accepted threshold of information is individualized risk benefits and alternatives.
When you testified that for many medical procedures, there are generally accepted risk benefits and alternatives that would be expected to be disclosed. What did you mean when you said generally accepted?
I meant generally accepted, but you asked me what percentage risk of hemorrhagic stroke that the provider should disclose, and that I don't know.
I'm sorry, I don't believe I did ask you that. What I'm asking is what do you mean by the term generally accepted risk?
I mean that a reasonable practitioner would disclose, or that would be the best evidentiary standard of practice.
Okay, so, and isn't it true that a generally agreed upon definition of what needs to be, sorry, isn't the standard by which we judge the standard of care what a reasonable physician would do in the same situation?
Sure, in a court of law in Michigan, that's the standard, yes.
So if the generally accepted if the generally, pardon me. The generally accepted risks are risks that reasonable practitioners would disclose, then, and that is the standard of care to be a reasonable practitioner. Doesn't that mean then that there are generally accepted risks, benefits, and alternatives that if you're meeting the standard of care, you have to disclose?
Sure, as long as they're individualized.
Okay.
Yeah.
So a doctor could look at the risk of hemorrhage and medication abortion and say, well, I know this is what a reasonable doctor would disclose, but I'm not going to do it because I don't think it applies in this case.
So if a doctor did that and the patient suffered from a hemorrhage, then the patient would have a claim for liability because the doctor didn't disclose that risk and it occurred to them and resulted in harm.
You're a licensed attorney, correct?
I am.
And you believe that the challenge laws undermine informed consent because they're fundamentally inconsistent with the common law doctrine of informed consent?
I think they're both inconsistent with the common law doctrine as well as the ethical doctrine, as well as the clinical standard for informed consent.
But to be clear, a statute passed by the legislature supersedes common law, right?
Sorry, I don't practice litigation. So I don't actually know that that is true in all cases, but I will accept it to be true for purposes of the questioning.
Are ethical standards aspirational?
I guess in some circumstances you could describe them that way, but in many, if not most circumstances, they are not aspirational, they are expected.
Okay. And the law, you have stated in testimony, you consider the law to be a floor and not a ceiling for good behavior, correct?
I do.
So would ethical standards be above the law or below the law?
Well, I think in the area of informed consent, one of the reasons that I find it so interesting as a lawyer and an ethicist is often they're very symbiotic. There are circumstances in which the law and the ethics can be very different. And so I think that ethical policies and standards are particularly important. But in the area of informed consent, the law and the ethics have developed hand in hand in a way that is a bit unique.
What does that mean? I don't know what you mean.
Sure. So in one of my areas of expertise is informed consent to data sharing, and federal and state law allow for very broad patient data sharing and outside the auspices of the hospital, including with commercial entities. And that is somewhere where if patients don't expect their patient information to be shared with commercial entities and they don't feel like they've consented to it, that's a good example of a place where ethical policy can actually improve upon the law. However, in informed consent, the common law of informed consent and the ethics of informed consent have really developed hand in hand, and often ethical articles will cite classic legal cases and classic legal cases will cite ethics philosophy.
Can the state pass a statute that sets informed consent standards, or is that just off limits?
I believe that there are a lot of statutes that the legislator has passed that sets informed consent standards.
So the legislature does have authority to do so.
I'm
Correct.
not a court, but I know that the legislator has created informed consent standards in the state of Michigan.
Right. You were asked some questions about the law. And I just want to be clear, I understand the law at issue. And I just want to be clear, I understand your understanding of the law. I believe it's, is it one? Is it one from the binder you have? Now, you were asked about section 11. Subsection 11, I believe it's on page 3.
Yes.
Is it your understanding of the law that the law requires a physician to give the depictions of fetal development, all of them, to the patient? So in other words, week 2, 4, 6, 8, are they all required to give?
That's not my understanding of the law. I think
Okay.
in practice, that's largely what happens, but that's not my understanding of the requirement of the law.
Okay, your understanding of the requirement of the law is that 11 doesn't actually require the physician to do, subsection 11 doesn't actually require the physician to produce anything. It's not subsection 11 that does that. It's instead subsection 3, right?
Well, so subsection 11 is a directive to the Department of Health and Human Services in the state of Michigan about what they are supposed to produce. And then subsection, what are we? 3B, little 3, then says, that the physician shall do not less than 24 hours, and then B, orally describe each of the following, then little c, information about how to obtain pregnancy prevention information through the Department of Health and Human Services.
Right. So, but in other words, subsection 11 states that the Department of Health and Human Services has to prepare or make ready a depiction of fetal development, right, at 2-week intervals, right? So in other words, this law requires just that the department actually make that literature, right?
That section of the law requires that the department produce that literature, correct?
Right. And then subsection 3C, and why don't we go with D, because we just talked about the fetal development.
So 3D,
Yes.
okay.
And that's the one that actually requires the doctor to provide the description to the patient, correct?
Correct.
Does that description D require them, the doctor, to give every depiction to the patient?
It doesn't. It says at the gestational age, nearest the probable gestational age of the patient's fetus.
Yeah, so that's individualized, yes?
No, it's not individualized because a picture of a fetus at any week is not relevant to an informed consent standard. And so just because information is individualized doesn't mean it makes an informed consent.
But I did ask, it is individualized, right? That was my question. I know you may be anticipating where I'm going with it, but I really need you to answer the question. So my question was, because they're only getting the picture that corresponds to the gestational age of the fetus they have, right?
Well, it only requires that the practitioner provide the image that is closest to gestational age. But in my understanding, many clinics provide all of them, as opposed to sort of cutting out the picture of the fetus from the pamphlet and handing it to the patient.
But the law itself, you're a JD.
I am a JD.
The law itself doesn't require that the physician, the clinic give them all the pictures, correct?
Correct.
Yeah. And the same is true for C, right? In other words, if you look at 11D, which you were asked about, right? Which if all we focused on 11D, we might be misled. But 11BI says,
Sorry, 11.
11BI on page 3,
BI,
it says,
yep.
Describe individually and on separate documents those medical procedures used to perform abortions in the state, right?
That is what it says, yes.
Yeah, and so that section there requires them to make ready those descriptions of the procedures, correct? Like department has to spend energy and money developing those descriptions of the procedures, right?
It shall develop is
Yep.
what the statute says.
Right?
Right.
So it will make them,
Yes.
but it's section 3, sub 3C doesn't require, the law does not require that the patient receive each and every one of those descriptions of the procedures, right? It only requires the procedure that corresponds to the description that corresponds to the procedure the patient will undergo. Right?
Right.
Okay. So if a clinic or a doctor is giving all of them, that's them not following the law, right?
I don't know if it's them not following the law, but it is, I mean, certainly my understanding of this statute is that you could put different sections of the informed consent form.
Yeah, well, I mean, specifically speaking, the descriptions of the procedure is supposed to be on separate documents, right? Isn't that section 11F or sorry, 11BI?
Sorry, can you repeat that?
All I'm saying is that the procedural descriptions,
Yes.
they're supposed to be on separate documents, right?
It says.
That would be on page 3, 11 sub BI.
Responds and provided by the health. And so what are you referring to in the statute? My
Well,
apologies, which
In
section?
response to your comment
Yeah,
that you could cut them up,
sure.
right?
Yeah.
They're supposed to be on separate documents, so there's no cutting up involved. You just provide the document.
Where does it say separate documents? I mean, that is also consistent with my understanding, but I don't see it at the moment.
Sub 11, A,
Sub
B,
11,
one.
A, B.
I,
one.
we'll say I.
Yes, it says individually and on separate documents.
Right.
Yes.
So at least in that regard, to the description of the fetal development and the description of the procedure, the law's requirement is that it be individualized. I understand your objections to mandating material, but in terms of individualization, all the law requires is the corresponding fetal development depiction in none of the other ones, and the corresponding procedure in none of the other ones, correct?
No, because it's not individualized, because one, as we've discussed before, not everybody's fetus looks like the pictures, for example, if they're suffering from some fetal abnormality, and also the risks and benefits and alternatives of the individualized procedures, even if we cut out just one, are not generally relevant to all patients depending on their underlying comorbidities.
So is it my understanding then that patients can't be given general medical literature? Is that right?
No, patients receive general medical literature.
Yeah, and it's common practice, isn't it?
Common practice for patients to receive general medical literature. I would say it is not common practice for a physician to hand out general medical literature. That's usually the role of the physician, is to interpret the medical literature and help the patient apply it to their values.
So doctors don't hand out pamphlets on certain procedures or certain types of care to their patients and have them read it at home? Is that what you're saying?
So sometimes, at least in my experience at the University of Michigan, we have general pamphlets that might be in a waiting room or even in, so the general wait room or even the patient room. And sometimes after a conversation, a clinician might say, here's some additional information if you want to look it over with your partner at home. But I have not, in my either personal experience as a patient or my professional experience as a clinical ethicist, seen a doctor just provide a patient with a brochure and say, think about this.
It's not what I said though, is it? I just said, is it okay for them to hand it to them? Can a doctor hand educational pamphlets to a patient?
It wouldn't be the clinical informed consent standard. But
Well,
yes,
but-
I mean, there's no prohibition for a doctor handing a patient something. It's just not informed consent.
No one is saying that this DHHS material is sufficient to obtain informed consent, are they?
Well, it's mandated that patients receive it 24 hours in advance.
Is it your understanding that merely giving a patient this material here is sufficient to obtain informed consent? Is that your understanding of the law?
No, of course not. It's
Okay.
not sufficient to obtain informed consent, and actually it undermines it.
In fact, abortion clinics have to continue on with the informed consent process, right?
Well, yes, that's what informed consent is the individualized conversation between the practitioner and the patient.
Yeah, which can include patient education materials, correct?
There's no prohibition. Generally, practitioners have a conversation with the patient because, again, general patient materials are general.
Yeah, and you can start with general materials and then you can go to a patient or doctor-patient conversation, correct?
There's no prohibition against that. I haven't seen that regularly in my practice.
You have not?
That a doctor walks into the room, hands a patient a pamphlet, says, read this, and then after I will have a conversation with you? No, I've never seen that.
Can a doctor refer a patient to a website like cancer.org?
Again, a doctor can. I would not say that that is typical. And in fact, if I, as an ethicist, saw a doctor walk in and tell a patient to go look it up online, I would be concerned.
Okay, so your understanding is that's bad practice for a doctor to tell a patient during a patient education session that they could go look some stuff up at cancer.org.
I think it's bad practice for that to be the only component of informed consent.
Again,
Yes.
I didn't say it was the only component of informed consent. A lot of my questions are like this. I'm not saying, is it the only portion of informed consent? I'm asking if it's allowable in informed consent, in the informed consent process.
Yeah, of course, there's no prohibition
Yeah.
against that.
And in regards to handing a patient a pamphlet, no, is it your understanding then that intervening defendant's position or any of its experts' position is that the remedy for irrelevant information is that the doctor would tell them to throw it out? Is that your understanding?
I'm sorry. Is it my understanding of whose perspective that somebody should, sorry.
Well,
I didn't quite
you've been
follow
asked
that
a lot of
hypothetical.
questions.
I have been.
Yeah, and one of the questions went along the lines of, is it appropriate remedy for the problems identified by yourself and
Mhm.
others for a doctor to just tell a patient, just throw that away? Is it your understanding that that's the remedy in this, the only remedy in this law, that it's to throw the literature away? There's not let me ask it another way, because that is a confusing question.
Mr. Tuttle?
Yeah.
How many more questions do you think you have left in your cross exam?
Well, I have cut my outline down significantly, but I do think I have like another 30 minutes.
Okay, with then redirect, I think that is this an okay time to adjourn for the day?
I think so.
Can I just note, I don't have any redirect at this point, so I don't know if it's possible. I know the court closes at 4, so I totally defer to what's.
Yeah, I don't know if other defendants may have examination questions that they want to give, and I don't want to foreclose redirect if you need it. And I know that we're going to get pretty tight on time. So if this isn't an appropriate time to stop for the day, thank you, Dr. Baghdadi.
Of course.
We'll, start again tomorrow morning with your examination.
Could I just ask for planning purposes, if we could try to get estimates of how long the directs will be tomorrow? As Your Honor has seen, the day has been spent. We asked 2 hours of questioning. I'm just trying to plan the representations that were made last week, 2 weeks ago, have all fallen apart, and we do all have lives, no clean clothes, nowhere to stay. So it would be great to know if we're going to be here. You know, we have childcare to arrange. We're going to be here tomorrow, Thursday, Friday. How long is this going to keep going?
I understand, Ms. Kelly, and I am,
I appreciate it. I understand, Your Honor. I understand why we can't move things along. It would just be great to get some representation so we can try to make contingency plans again.
I think one of the things that we're running up against is that we can plan for one thing and then you get to trial and something else happens. And this has been a particularly interesting trial because it's been almost exclusively with expert opinions. And as I'm sure you will be showing me tomorrow in cross-examination of theirs, one of the only ways, especially since I'm sitting as the fact finder, one of the only ways that the expert's opinion can be impeached or can be fleshed out or differentiated is through cross. So I don't want to curtail that for either party.
I'm not asking you to, Your Honor. I'm just asking if we could get an estimate from the intervening defendants that was somewhat close to accurate. Their directs, I presume they know the questions, they practice them. They could give us something close to accurate of what their directs would be so we can make plans on how many more days.
Fetal, Mr. Asmussen.
I don't know that I can give you that number right this minute, but
Can you give
I'm-
an estimate?
I'm-
Are you,
I'm hopeful that we can get through all three and finish this one and get through the other two. I don't expect that Dr. Curlin will take an excessive amount of time, though I'm the one offering him and I can make a very efficient direct examination. But as I have learned from many trials of experience, the cross-examination of an expert can be long because you need to tease out more than what you can do on direct. So they are typically longer. So my estimation.
Sorry. Just want to estimate, Your Honor. I don't want to keep the court here. Like, is it an hour? Is it 3 hours? Is it?
I mean, if I was to stand here right now and I don't feel that I want to bind myself to it, I would say we have maybe an hour with Dr. Curlin and maybe 2 hours with Dr. Rubenhorst, but it could go longer than those.
Thank you, Your Honor. I appreciate that.
is there anything else that we need to discuss before we adjourn for the day? Okay, I appreciate everyone's patience. Thank you very much, and we stand adjourned for tonight.